Welcome back to day 4, everyone. Before we begin, a quick disclaimer and content warning. This video contains discussions of allegations that are very distressing. Conversation and details regarding SA, domestic violence, threats, and other disturbing content matter. Please remember to take care of yourself while you watch. And remember that it's okay to step away if this one's too difficult to listen to. As always, the defendant is presumed innocent, unless and until proven guilty in a court of law. This video is commentary, and the opinions and gut reactions you see are just that, from the gut as I edit and watch and react simultaneously. Today we pick up with the defendant still on the stand, and if you've been waiting for the defense to finally bring us a coherent explanation for all of this, you might want to lower your expectations immediately. With no preliminary matters this morning, we jump right back into testimony and walk through another mountain of text messages. Unfortunately for everyone involved, the defendant appears to have developed a remarkably selective memory. Many of the messages, doesn't remember them. Conversations, doesn't remember those either. The threats, well, even if he did say that, who cares? He never acted on them, so don't worry about those. I have to be honest, I really don't know why this man chose to testify. If his goal was to try and help his case, I'm not convinced that it's working. He never really presents a theory that makes any sense, and some of the questioning is so bizarre that it kind of feels like it's a cross-examination assist for the prosecution. Speaking of which, cross-examination is pretty explosive. The prosecutor methodically dismantles the defendant's testimony piece by piece, pointing out the inconsistencies and more inconsistencies and more inconsistencies. He highlights explanations that simply don't add up, and at one point, the defendant literally has to use his fingers to count backward from October to April to figure out which month it is. Folks, we're dealing with a true intellectual here. Honestly, it's a miracle that his shoelaces continue to cooperate with him. The prosecutor repeatedly asks whether the defendant has memory problems, and at more than one point, whether he's high. And after some of the answers, you'll understand why he's asking. Redirect does very little to repair the damage, and eventually the defendant is released from the hot seat. But before he's done, something we've been waiting for. The jury asks their very first witness question. They want to know if he has personal knowledge that the alleged victim is making these accusations because of his relationship with her friend Minnie, and whether he has personal knowledge of when she supposedly became aware of that relationship. I won't spoil the answers, but let's just say they were interesting. So when he's finally relieved, or rather, when we're finally relieved of him being in the hot seat, it's time for rebuttal. And we will hear once again from Detective Brannon. I think that's enough spoilering for now. So grab your coffee, grab whatever you're going to need to keep yourself in check, settle in, and let's get into it.
All rise.
Good morning. Thank you. You may be seated. And sir, please raise your right hand. You swear or affirm that today's testimony will tell the truth, whole truth, and nothing but the truth under penalty of perjury.
Yes.
Thank you. And have a seat. And you are Andrew Gobergs, correct?
Yes.
And counsel, you are in the middle of your direct. You may proceed.
Yes,
Sir, you remember the rules. Let counsel finish. If you don't understand something, let them know. They'll rephrase. If you break, let me know. Use words that can be found in the dictionary. And if there's an objection, don't answer till I tell you. All right. Any questions? All right. You can ignore me. Talk to the jury. Counsel, you may proceed when you're ready.
Yes, thank you very much, Your Honor. All right, thank you. Good morning, Mr. Brooks.
Good morning.
I meant to ask you this yesterday and I forgot. Have you ever testified in a court proceeding like this?
No, I'm not.
Is it safe to say you're nervous?
No.
You're being nervous. Is that going to have any effect on whether your answers to questions are truthful?
No.
Thank you. We've got a bit of ground to cover. I'd like very much to ask you some questions about what's been admitted as evidence in this trial. starting with these text messages.
Brian, here, switch to the other one.
I'm sorry.
Brian,
No, use that.
no. Thank you.
Do you have the
I
answer?
can go a different direction for a few minutes.
That's fine.
Okay, thank you. We'll come back to these in just a moment, Mr. Brooks. Right now, I wanted to deviate just a little bit, and in a general sense, the language that's contained within these messages that are attributable to you, nasty, pretty awful. Is that language you use all the time?
No.
Well, then I guess the question is, why did you choose to use that language in your text messages to Ms. Clark?
It would be every time we would get into argument or something.
I'd like to show you what's already been admitted. It's People's Exhibit number 9. Can you see that from where you're sitting, Ms. Brooks?
Yes.
Thank you. There's a date, May 6, 2020. Do you see that?
Yes.
And the left-hand portion in what is in the not shaded blue, are those your words that you sent?
I don't recall.
Okay. Got a time at approximately 10:30 in the evening. Does that assist you? Remember?
No.
Well, it says here, I'm going to fuck up your life up. Just sit back and watch. Do you have a memory today as to what you were referring to at the time?
No, I don't recall this text.
Did you, from time to time, text back and forth, you and Ms. Clark?
Yes.
During the times that you were together, did you have your own, I don't know if they're called cell phones or handheld devices, but did you have a cell phone?
Yes, I did have a cell phone.
And do you have personal knowledge as to whether Ms. Clark had one?
Yes, she had one as well.
And would she from time to time respond in like kind in a text message?
Yes.
Some of these intimate either future assaultive behavior or killing Ms. Clark. Did you develop any kind of a plan to kill her?
No, I never came up with the plan to kill Ms. Clark.
All right. We talked about strangulation yesterday. I think you said that you never choked her or strangled her. Is that right?
Yes, correct.
And what about other assaultive behavior, assaultive battery behaviors, whether with your hand or fist or with an object? What do you recall about your being physical with her?
Like I stated before, we got physical altercations, a lot of pushing, grabbing, shoving, things of that nature.
Okay. Let's jump to People's number 10. Excuse me. I'm looking at this. Well, you can see it from where you're at, can't you?
Yes.
Are you able to tell us whether these are words that you sent to her or vice versa?
No. It appears from Melissa.
Okay. But you have no memory of it today.
Yes, correct.
Thank you again. All right. This People's Exhibit number 10 consists of more than one page. As you see it now, do you have a memory of this being created?
No, I do not.
Do you have a memory today as to whether May 18th, 2020 was significant in some way?
No, I do not.
If you threatened to beat her ass, did you follow up and actually do it?
No, I don't remember this text at all.
Okay. So in a general sense, do you have a memory today of threatening her and then following through?
Yes, I have threatened her in the past, followed through, yes.
And tell us more about that, please.
Threatened her like a time I said, if you don't take the photos down of me, I'm gonna post them of you, and I did do that.
Okay, we're going to get to that a little bit. Right now I'm focusing on assaultive behavior, battery, hitting, punching, kicking, physical. Did you threaten to harm her physically and then follow through on it?
No,
Have you ever assaulted her, physically out of anger?
yes.
And tell us about that. Well, first I should say, was there one incident or more than one?
Probably about 2 or 3, I remember.
Was that over the entire course of your relationship with her?
Yes.
If there was a first one, do you remember?
2018.
And tell us about that, please.
I went to the bathroom, and when I went to the bathroom, I was taking a shower. She went through my phone. I had it on the charger. When I came back in, she confronted me about speaking with somebody. We got into a big argument. I tried to tell her to leave. She wouldn't leave, so I pushed her out the house.
You pushed her out of which house?
1701 Millstone.
Okay. From your memory of that incident, was there any indication by her that she was harmed, hurt, injured?
No.
Okay. Recall a second time? There was physical touching of her person by you?
Yes, 2021.
And in 2021, what's your memory of that episode?
Similar, basically over cheating. That's how
Basically, I'm sorry, over cheating.
Yes, ma'am.
Now I have to ask you, can you repeat that?
Yes, it was basically the same scenario. I was sleeping, she went through my phone, called me cheating again, we got into an argument. A lot of pushing and grabbing, she grabbed my dreads, I grabbed her hair.
All right. You grabbed her hair. Should we all assume that was with your hand?
Yes,
One hand, both hands?
I don't recall.
And did you alter her direction of travel when you did that?
No,
Did she complain of pain of any kind to you after?
no,
Do you have a memory today as to whether she ever went to a hospital during your relationship?
no. I know she went for
You don't?
No.
Okay, thank you. Did you ever take her to a hospital?
No.
Thank you. So if People's 10 does say, I'm beating your ass, your testimony is that even if that's your writing, there was no physical follow-up to it.
No.
This is, People's Exhibit 11, it's another text. Do you see the date, May 25th, 2020?
Yes.
Okay. Do you have a memory of that day?
No, I do not.
I'm smacking the fuck out of you, bitch. Is that something you wrote and sent to her?
No.
As you look at this, does it appear to be a back and forth as between you and Miss Clark?
I don't remember these texts, so I'm gonna say no.
Okay. If you don't remember them, are you able to tell from this exhibit whether you were involved? Your phone, did you make these texts and send them? You just don't remember?
Correct, I just don't remember.
All right. Do you dispute that it is a string or it's just several back and forths between you and Ms. Clark. Do you dispute that?
These text, yes.
Okay. Do you understand what I'm saying? I appreciate the fact that you're telling us you don't remember. Okay. But now that you see this, are you disputing that this does not represent conversations between you and her? Consists of more than one page. I'm showing the second page. Exhibit 11. Does that refresh your memory of a conversation by text with her that day?
No.
The next is Exhibit 12, deals with September 15th, 2020. Can you see that from where you're sitting?
Yes.
Does this look familiar to you?
Yes.
Okay. On this particular exhibit, number 12, you have a memory of sending those words to Ms. Clark?
Yes.
And is it you or Ms. Clark in the blue?
That would be Alyssa Clark.
All right. It says, talking about asking whether she put on some makeup. What was that all about?
That was the day she bought her best friend.
And where did that happen?
At the 2700 E Rapids Road address.
Were you there at the time?
Yes, I was there.
Okay. What was the issue with respect to? Oh, you're not talking about cosmetics, or were you? Were you talking about cosmetics, or were you talking about makeup, like apologize?
Cosmetics.
Okay. Why would you ask her whether she had put on cosmetics?
She set up her friend, they got into a fight, and she didn't get the better end of it. So she had like a little bruise under her cheek.
And when you say she, of course, you're talking about Miss Clark.
Yes.
All right. And did the encounter that you just described result in a physical injury to her, something you could see?
Yes, it did.
And was that caused by you?
No, it was not.
Did was anything else planned for that day? Did you or she or both of you have appointments to be somewhere or go somewhere, if you recall?
No.
We heard some testimony about CPS, and the date on this is September 15th of 2020. Do you have a memory as to whether at about that time CPS was conducting an investigation? If you recall.
No, I don't recall.
Is it you don't recall when, or you
I don't recall when.
Okay, you're not disputing CPS got involved from time to time?
No.
All right, thank you. You recall if you were scheduled to meet with CPS that day?
No.
September 15th of 2020. Do you have a memory today as to whether Ms. Clark was scheduled to meet with them that day?
Yes.
And did they usually come to the house, or did you or she usually go to see them?
We would go to CMH.
Can you see the second page of this exhibit from where you're at?
Yes, I can.
It says, I will take these TV and fuck this crib up. What were you thinking? What does that mean when you sent that?
Are these supposed to be the same date as the other text?
Well, I can't say. That's September 15th. I see a time of 9:02 at the top, and I don't know if you can see this or not, but there's a time of 11:22 a.m. the following day, September 16th. It would appear to be either the 15th or 16th, but I can't see any more than you can see.
Yes, I don't recall those.
You do?
I don't recall those.
Okay. You ever tell her that she was yours for life?
Yes, at one point in time.
Did you intend that to be a threat or something else?
No, not to be bad.
Okay. Well, then what did you mean when you told her that she's yours for life?
That's just something we always say to each other towards the beginning of the relationship, I guess you'd say.
Anything about this text message back and forth that causes you to remember whether there was any altercations between the two of you that day?
Yes, this one I was telling her to take the video that I spoke about earlier.
Well, tell me again.
Yes, this was me when I was texting her about the video. She posted it. This is me telling her to take it out.
After having read this exhibit 12, is it your testimony that that's what essentially this was about, the back and forth having to do with something she posted?
Yes, correct.
All right. Are you familiar with Facebook?
Yes.
During the time that you two were together, Ms. Clark used Facebook as well?
Yes.
All right. Now, someone who doesn't use it or doesn't know too much about it, what is it?
Facebook is just a social media website or app where you can promote products, add people, connect with people around the world.
All right. And with some testimony about private versus public, are you familiar with those two words with respect to Facebook?
Yes, I am.
Can you help us understand one from the other?
Yes, you can make a post that's public for anybody. If they look up your page on Facebook, anybody will have access to it. And you can make the settings to just friends. So only friends on your Facebook can see it. Somebody random wouldn't be able to go to your page and see it.
All right. I just want to take this one step at a time. You're not saying that you didn't ever post something with respect to Ms. Clark on Facebook, are you?
No.
All right. Did you post on Facebook any image of her undressed?
I'm sorry, like a naked picture?
Yeah.
No.
What's your memory today as to?
Just a moment.
I'm sorry.
I got it. Thank you. You may proceed.
Thank you. Do you recall what image of her you did post?
Yes, I posted a picture of her stomach and her teeth.
And you're saying teeth, like teeth in your mouth?
Yes.
Okay, thank you. And what caused you to do that?
The video she posted of me on her social media.
And when you say you posted those two images of her, did you do that in a private setting or public setting, or?
The picture of her stomach private, the picture of her teeth was public, so anybody could see it.
Okay. And you have experience creating or making a video from your phone?
Yes.
Okay. And are you familiar with the idea of taking a screenshot from your phone?
Yes.
What is a screenshot? Tell the jury, please.
A screenshot is basically anything on your phone that you're seeing, you could save it to the phone gallery.
And whatever you see on the screen at the time, that's what?
Yes, video, picture, anything.
Okay. Are you familiar with process of taking a screenshot during the viewing of a video,
Yes.
is there anything different one as to the other? A screenshot of something that's on your screen, or attempting a screenshot from a video that you'd be watching?
I'm sorry, could you refer to that?
Sure. If in your experience using these various items, is there anything about the screenshot from the video that's different from another screenshot that's not from a video that you're watching?
Yes. If we take a screenshot from a video, it would essentially show the video at the bottom of the screenshot. Trying to think of a way to explain it. So if you're watching the video, it'll show you the timeline at the bottom, like the video. If you screenshot it, that'll be at the bottom of the picture. Now, if you're just screenshotting, let's say a picture you're trying to send to a friend, it's not a video, so there's not going to be nothing at the bottom. It's just going to be whatever's on the phone at the time.
Is it your understanding that's true? That's a true distinction every time?
Yes.
Okay.
Your Honor, I'm going to actually object to that as it calls for an expert opinion.
I guess if he was, I'm not asking for an expert opinion, just what does he see when he uses these things?
I'm going to allow him to answer it as a lay person, and it is distinct from an expert opinion, so it's his opinion. I'll allow it as his opinion. It's already in the record. Thank you.
Thank you, Your Honor.
And just to recap, you had two images. One was a screenshot and one was taken from a video. You could tell which was which.
Yes.
Okay. Did you cause to be created, or did you create a video at the time when Ms. Clark was sleeping, passed out, unconscious, anything like that?
Not a video, no.
Okay. Did you take single digital images?
Yes, I took a picture.
Okay. If you recall, more than one?
Yes.
Okay. But you did not make a video?
No.
Okay. At the times that we're talking about, because I know that you were in the room when she testified, in the time frame that we're talking about, did you insert an object into her or your penis into her while she was in the state that we saw in those photographs?
No, never.
Yeah. Do you recall seeing, and I'll keep looking, but do you recall seeing an image that was admitted as evidence, and it was of Ms. Clark from about shoulders up?
Yes, I do.
And did you notice that her eyes were closed?
Yes.
The photo that I'm referring to and trying to find, you don't dispute that you took that image?
No.
Yes.
I believe it's 42 and 43 which would be on the table.
Yeah, if only I could hear you.
I believe that it's numbers 42 and 43 that you're referring to should be found on the table.
My apologies, Your Honor.
It's okay. Take your time.
I'm now putting People's Exhibit 42. And can you see that from where you're sitting?
Yes.
Do you recall having seen it before in this trial?
Yes.
And is that, I'll just say, photograph that you took?
Yes.
And given what you've just told us, is it your position that that was not taken from a video?
Correct. It was not taken from a video. It was a picture.
Okay. Help me just Describe in as best detail you can this symbol or something that's would be visible if it was from a video.
At the bottom of the picture, there would be the video. Probably 1 inch tall, that'll show at the bottom of the screen.
What would its shape be?
There would be basically the play button. So it would be a circle with a triangle in the middle.
Thank you. You have viewed videos before on your phone?
Yes, I have.
What's your experience in terms of that button?
That's the play button.
So if you touch it, the video will proceed?
Yes, it will.
What happens if you touch it again?
It'll pause.
All right. And if you try to take a screenshot, a still photograph of it, that symbol will nevertheless be, you can see it in the still photograph.
Yes.
Do you see that symbol in People's Exhibit 42?
No, I do not.
Do you see that symbol in People's Exhibit 43?
No, I do not.
Do you see it in People's 49?
No, I do not.
What about People's 50?
No.
51, do you see that symbol?
No.
52.
No.
Thank you. Why did you post something about her teeth?
That was the incident where the video, she had the video of me up. I've asked her multiple times to take it down, and she told me it was taken down twice, and it wasn't. So that was an attempt to try to get her to take the video down.
Did you try to strangle her there? Or did you strangle her or choke her?
No, I did not.
Were you in her presence, were the two of you together before she became unconscious?
Yes, we were together.
All right. If you recall, was there arguing, fighting, anything like that?
No.
And did you post what's been admitted as People's 52? Did you post that on Facebook?
Yes, I did.
And what about 51?
No.
The posting of People's 52, was that public or private?
That picture was public.
Did you indicate, if you recall, anywhere on the posting, in addition to the image, any writing identifying who it is?
No, I did not.
Have you ever viewed a video like the one that Ms. Clark described for us, having to do with her being unconscious and naked?
No, I'm not. I don't know how was that video at all.
People's 44, bitch looked like a Dalmatian dog with all them spots. Is that a photograph that you took?
Yes, it is.
Is that a writing that you authored?
Yes, it is.
Did you post it on Facebook?
Yes, I did.
Did you post it privately or publicly?
This one was public.
And was it in the same condition that we see it now, or was there more of the image?
Yes, it's the exact screenshot of what was posted.
Okay. Do you see various squares on the image here?
Yes, I did.
Yes, you do?
I do.
Okay. Did you cause them to be on there?
Yes, I didn't want to post her naked picture, obviously. She's the mother of my child, so I covered it just in an attempt to get her to take mine down.
This comment about a Dalmatian dog with all those spots, we can all see this image. Help us understand a little bit more about these spots.
Yes, so I don't know, she had something going on with her skin, and at the time she was hiding it from me, so I'm not sure when it started, but every time we would like sleep together, she would turn the lights off. So I'm not sure what you're asking. I'm sorry. Can you repeat that?
Well, let's start at the beginning.
Okay.
The image that is People's 44, does that show some of the spots that you're referring to in your writing?
Yes, it does.
Is that the only part of her body where they appeared?
No, it's not.
What other parts of her body had these spots?
They were on her upper arm, her legs, her stomach, her feet, her back.
Do you have personal knowledge? I mean, were you there? Did she, if she ever sought treatment for that?
No.
Showing you what's been admitted as People's Exhibit 1, can you see it from where you're sitting?
Yes, I can.
All right. And People's Exhibit 2, which has also been admitted, our understanding is that that's the same arm on the same day, just a little bit closer. Do you dispute that?
No.
Okay. Any marks on there? Do you have information as to how that they were formed?
Yes, I'm pretty sure. I'm not 100% sure.
Then don't answer. I don't want you to guess.
Okay.
Yes or no?
No.
Thank you. Did you take that photograph?
No, I did not.
Okay. People's Exhibit number 3. Can you see it from where you're sitting?
Yes.
That has been admitted and described as a hand, wrist, and part of her forearm of Miss Clark. Do you see the mark on that photograph?
Yes, I do see it.
Did you cause that?
No, I did not.
Did you cut her with scissors?
No, I did not.
Did you cut her with anything else?
No, I did not.
Were you physically present with her when that injury was received?
No, I was not.
Did you ever threaten her with nursing scissors?
I've seen a pair of nursing scissors. I wouldn't even be able to tell you what they look like.
All right. So your answer is no?
Correct, no.
Thank you. People's Exhibit 4, you see that?
Yes, I see.
All right. And if that's bruising, did you cause it?
No, I did not.
You didn't punch her and punch her and punch her over and over and over on her legs?
No.
Okay. This is essentially the same thing, a slightly different angle. Did you cause any of those injuries?
No, I did not.
I don't want you to guess, and I don't want you to speculate. Do you know for certain how that mark was received? What happened that would cause it?
Yes, that was the night at Max Bar when I got into altercation.
And someone else did something to cause that?
Yes, I was getting jumped on by a few dudes. It led to the parking lot, and his woman, or I would assume it was his girlfriend, she came back with the bat and was hitting me. And Alyssa tried to jump in or break it up, and she hit her as well.
So Miss Clark was with you at Max Bar?
Yes, I had to show that night.
All right. And you said out in the parking lot, Miss Clark was with you out in the parking lot?
Yes,
And she was physically present during this confrontation between you and another person?
yes,
Did you two go there together, if you remember?
yes,
Did you two return together?
yes.
Where did you go from Max Bar? Where'd you go?
We went to our house in Stonegate, the 2700 address.
2700 Eaton Rapids Road?
Correct.
Why did you just now refer to it as our house?
Because it was essentially her house. It was in her name. I just moved in with her.
Okay. Was that by invitation?
Correct, yes.
What were the dates approximately that you lived with her and moved in with her?
I believe 2020, 2021.
Until, did there come a time when you moved out?
Yes,
When was that approximately?
21.
So how many months did you live together? Do you know?
Probably a little over half a year.
You may proceed.
Thank you, Your Honor. Tell me about going from living with her there to not living there. Was there something that happened? Was it mutual? Help me understand what caused that.
Yes, there was a lot of arguing going on because she kept finding out I was cheating, and I just got tired of it. It was to the point where I was hiding my phone from her when I went to sleep, and I just got tired of it, so I left.
In your opinion, was that the moment of what's commonly referred to as your breakup?
Yes, I never went back to her after that.
And in your opinion, did you cause the breakup or declare a breakup?
Correct, yes, I left.
Okay. Did you ever have a key to 2700?
Did you ever have a what?
A key, I'm sorry.
Yes, I did.
How did you come into possession of the key?
When I took her to get the.
How did you come into possession of it? Did someone give it to you?
One at a time.
Sorry,
I listened to it.
you're nervous, aren't you?
No.
Well, try to listen to the question and just answer the question, okay?
Okay.
Thank you very much. I know you want to say several things, but just stick to the question as it comes. Thank you. All right, as long as we're looking at photographs, we'll finish with these. People's number 6. We've been informed is a photograph of the inside of the 2700 Eaton Rapids Road address. Does that comport with your memory?
Yes.
Thank you. And is that also consistent with People's Exhibit 7?
Yes.
And I think there's one more. People's 8. Is it all the same mess, just different photographs of the same mess, if the best you can tell?
Yes, that's what it appears to be.
Okay. Do you have personal knowledge as to how that mess occurred?
Yes, I do.
And what is that personal knowledge? How did that room become such a mess?
I did.
Is that while you were still living there?
Yes, it was.
And did you have a reason for trash on the inside of that place?
Yes.
What was your reason?
It was when she was telling guys she went to Atlanta and her best friend was telling her she was basically a prostitute.
Help me, how does that cause you to trash the place where you live?
Because I texted her about it and she kind of was just blowing me off about the whole situation. She thought I was playing, but I was serious when I was asking her if she was a prostitute.
All right. Are you better able to explain that even with that as a background or backdrop, why you would trash the place where you live?
Yes, I trashed it. I was just mad and angry at the time. And it's something she's done when we lived at 1701. So I guess essentially being petty, getting back at that situation, I guess.
Well, you say that she trashed Grandma's place on Millstone?
Before, yes.
Okay. I don't need details, but just generally in that sort of same fashion?
Yeah, literally, I was out of town when it happened.
All right. Do you know today as to whether anyone...
I'm going to ask that all be stricken then if he has no personal knowledge of this incident he claims happened at Millstone.
That's fair.
Sir, do you have personal knowledge of this?
Yes,
How?
when I came back.
Well, what did you see when you came back?
The couch cushions were cut up, but the food was out on the floor.
And did you have any personal knowledge of who caused that?
Yes,
Who?
Alyssa Clark.
How?
She told me.
When did she tell you?
When I texted her about it and asked her.
And then it's hearsay. It's not personal knowledge. It should be stricken.
So you didn't see her do it?
Correct.
I'm gonna let it stand and let you cross-examine on it because it is already part of her testimony. And so I think that, and the jury's heard it, so I think it's subject to cross-examination and then further development if you would like on direct.
Thank you, Your Honor.
Thank you.
My thanks to the court as well. You weren't the only one that lived at that address on Millstone, were you?
No,
Your grandmother also lived there?
correct.
Do you know whether your grandmother was at home when this sort of a mess happened at her address?
No, she was working third shift.
Okay. Anyway, you don't have any information that she was home.
No,
Was this during a period of time that Ms. Clark was living with you and grandma at that house?
yes,
And you're not disputing whether she had access to the house?
No.
Would you agree that there were no cameras in the house or ring cameras outside or inside the house? I'm sorry?
yes, I would agree.
Okay, thank you.
Which occurred first? The trashing of grandma's place or your trashing of the Eaton Rapids Road address?
If you know,
Yes, it was grandma's house. It was before the 2700 address even existed for us.
Okay, thank you. Ms. Clark said that she lived with you and grandma on Millstone. Then she moved to her mother's house and then to 2700 Eaton Rapids Road. Is that your memory as well?
No,
What is your memory as to where Ms. Clark moved to when she left the Millstone address?
cousin's house, where she was staying. Her cousin's house.
Her cousin?
Yes.
Is that the same residence as your mom?
No,
And how do you know that?
I dropped her off there before.
Had you ever dropped her off at her mother's place?
Yes,
And is your testimony today the two places are not the same?
correct.
Okay. People's 41 has been admitted and identified, albeit the redaction notwithstanding, to be a social security card of Ms. Clark. You see that from where you're sitting?
Yes, I do.
And I don't have it in front of me, but I think there's another one of her Georgia identification. Do you remember seeing that?
Yes, I do.
Do you remember seeing a photograph of the Georgia identification in this trial?
Yes, I do.
Thank you.
I do want to say something. All right.
Well, there's no question in front of you. What did it have to do with one of the previous questions?
It got to do with this question. The video I'm talking about, she posted with me, is right there at the bottom of the screen to the right. There's 3 videos in them. That's the exact picture I'm saying that she posted. Right there. Go down.
This one?
Go down.
down
Right there.
There?
No, they're just
the pictures at the bottom, sir. The line of things that move your pen up just a little bit, hot,
Right
yeah.
there. Those are the exact pictures from the video she posted.
Oh, that she posted of you.
Yes, I don't know if you want to zoom in, but you can see it.
Okay. All right. Well, not really nervous. I want to talk about the social security card.
Yes, I posted it.
Okay. And how'd you get your hands on it?
She left there at 1701 Millstone.
She left it behind when she moved out.
Correct.
And what about that Georgia identification?
She left that too.
Do you know whether she secured a Michigan identification card or driver's license?
Yes, she eventually did, yes.
Okay. Why did you create this image?
This was all the same time frame from her posting that video.
Okay, it's the time frame. Why did you do this?
It was just another attempt to get her to take the video of me down.
Well, you wanted her to know that you had her social security card?
Yes, she knew I had it.
And is that also true as to that Georgia identification card?
Yes,
Okay. And whether in writing or otherwise, you said that you were going to post this social security card if she did not take down whatever she posted of you?
yes, correct.
All right. Did you post that social security card?
Yes, I did.
Were you attempting to sell it?
Actually, shut it down.
Did you post it privately or publicly? If you recall, don't guess.
Public, I'm pretty sure public.
All right. Did you accompany it with any writings of your own? Did you send a message along with it?
The message that was on the picture.
So your answer is yes?
Yes.
Now what are you talking about?
I just said it's for sale.
Did you type anything? Did you say anything about it in addition to the photograph of it?
No.
Thank you. I'm sorry, I wasn't more clear. I'm looking at it where it says good profile, someone can get it for $100. Are those words that you created?
Yes.
And was it your intent that they accompany this image of a social security card?
Yes.
How is what you said accompanied by the social security card? How is that not an invitation to sell it?
Nobody inboxed me about it.
What if they would have?
I wouldn't have sold it.
Okay,
The purpose was for her to see this?
To take the video down, yes. I wanted her to see that.
Yes. And if I'm understanding you correctly, your thinking, perhaps both, was that if she thought you had the ability to post this, and that you could, or that you would, if she did not take down what she had posted of you, you were hoping that that would cause her to take it down.
Yes, correct.
All right. And did she?
No.
I think that there may be an issue as to the previous photograph. There looked to be a yellow colored liquid of some kind in the photograph. Do you recall that?
No, I don't know what photograph you're talking about.
Okay. Well, it's the one with the trash house. You see that?
Yes.
Okay. Can you tell us whether that is your urine or not
No, that's not one.
in any of these photographs of the house trash?
Yes, I never urinated on anything. I never urinated on anything.
Thank you. Did there come a time when you contacted law enforcement with respect to some postings that you claimed that Ms. Clark had posted on Facebook?
Yes.
And what items on Facebook were you complaining about?
The items that were just shown in the picture that I referred to.
Thank you. And just for purposes of our record, that had to do with
Me giving her oral sex.
okay. You giving oral sex to her, is that right?
Yes.
Thank you. And how did that get you involved with law enforcement?
Well, this isn't the first time she's done it. This is the second time she's done it. So
when you say done it, be specific, sir.
this is the second time she's posted the same video.
The same video.
Correct.
Put it up, took it down, put it back up.
Yes.
And did you have contact with law enforcement?
Yes.
Tell the jury how that came about.
I was on bond. I was on bond for a case with her, and somebody, an officer from Baton Police, called my phone and asked if he said, "Hey, is this Mr. Brooks?" I said, "Yes." He said, I'm contacting you because I was just informed that you violated your bond. And I said, how did I violate my bond? He said, you contacted Mr. Clark. And I told him, I said, look, man, this woman been trying to take me down for years. I've been left her alone. I said, there's no text of me violating the bond. I said, she's actually got pictures of me posted right now.
Pictures of me what?
Posted right now. And he informed me, he said, sir, what you're telling me is true. You need to hang up and call the police and report that because you're just looking bad right now. He said, it's not up to me to believe you or her, but I advise you to call the police and report what she's doing to you.
And as a result of that information, did you?
Yes,
And which police department?
Lansing Police Department.
Did an officer come see you?
No, we spoke over the phone.
When I asked you, did an officer come see you? Your answer is no.
No,
Okay. And you had a conversation over the telephone?
yes, correct.
And do you have a memory today as to who you spoke to?
No,
And was there any subsequent or follow-up discussions between you and anybody in law enforcement about that?
no,
To sum up this idea of these text messages, should the jury understand your testimony that you do admit to participating in some, but you just don't have a memory of others?
yes. I can only admit to the ones that I have knowledge and memory of. Correct.
All right. Imagine it's possible that they were text messages between you and Ms. Clark. It's just you don't recall them today?
Yes.
Okay, thank you. We saw some video footage, black and white, that was, we were told it came from a security camera at 2700 Eaton Rapids Road. Were you here and did you see that?
Yes, I did.
The individual in the two separate videos, is that you?
Yes, it is.
And was it sometime during the winter months?
Yes.
And approximately what year or month did this video take place, if you remember?
November or December.
Okay. What year?
I don't recall the year.
Okay. We had something called COVID-19. Do you remember that?
Yes.
And explain to the jury how it is that there's two separate videos of you approaching the house.
Yes. So I went there to recover some of my clothes, well, the rest of my clothes from when I left. And when I first went, I just knocked on the door. She was in there, but our room was all the way pushed back. So I was knocking hard. Nobody came out, so I left. I went to the store up the street to go buy a bottle. So I put my mask on. And before I went back to 1701, I was like, I'm gonna try to go back again. So I went back, and that's why the second time you see me coming back, I have a mask on.
And that was your intent or your purpose was to safeguard against the virus?
Yes, correct.
All right. And then your return visit, was there any indications that she was home at the time?
Yes.
And the second time, did you knock or ring the bell or whatever was appropriate to announce that you were on the porch?
Yes. I knocked.
Did you get any response?
No, that's why in the video you can see me smacking the camera.
Did you attempt to gain entry even though she did not open the door?
No, I did not.
Did you walk into that residence that day because the door was simply unlocked?
No, I did not.
Did you ever enter that residence after you had surrendered your key and you said that the dating relationship was over?
No, I did not.
All right. Did you damage a door or a window at that address?
No, never.
Okay, thank you. it is claimed that you walked into that residence without permission and that you assaulted her after you entered, once you were inside. What's your reaction to that?
That incident never occurred.
If you know, do you know Ms. Clark well enough to know whether she saves text messages, digital images, including photographs, things like that?
Objection calls for speculation.
If he knows, he lived with this woman they have 3 children together. He might have an idea as to whether she does.
Do you know if she saves text messages or not?
Yes,
How do you know that?
I've seen them in her phone.
I'll allow it, we proceed.
Thank you. If you know, does she save digital images?
Yes,
How do you know?
I've seen them in her phone.
Let's talk about the pistol that has been offered and admitted as evidence. You're not disputing that you had possession of the firearm that was in the box.
Correct.
All right. And do you dispute that you kept it between the mattress and the box springs of a bed?
Correct.
Did you know at the time you possessed that firearm, it had been reported as stolen?
No, I did not.
When did you find out?
I found out when police officers came to my house and they ran the lien, I guess.
Do you know whether that's the law enforcement information network or no?
I'm not sure.
Okay. Do you have access to law enforcement records?
No, I do not.
Did you ever point that firearm at Ms. Clark?
I never possessed a firearm during our relationship, no.
You didn't possess it?
No.
You obtained it after?
Correct.
You put together, I understand, a couple of music videos, is that true?
Yes.
And did you either hire or did you have somebody help you with that?
Yes.
Do you recall the person's name, if you do?
Yes.
What is it?
It's Juan's videos.
I'm sorry, can you say it a little more slowly and so our recorder can make sure she spells it correctly?
Yes, it's Juan's videos.
Thank you. And with respect to you and Juan creating a music video, who provided the equipment to actually do the recording?
The person shooting the video.
That wasn't Juan?
Yes, it was Juan.
Okay. He provided whatever camera it was.
Yes, you can pay him for a standard music video.
You can what?
You can pay him for a standard music video, or you can pay more and he'll bring props such as like lighting.
Did you hear me ask you that question?
Yes.
Okay. What else did he provide other than the mechanical mechanisms to record whatever it was you wanted to record? I'm going to call it a camera. I'm sorry. I'm going to just call it a camera. Okay.
Yes.
All right. So besides the camera, what did he provide for you?
You can pay extra for prop money, lights, firearms.
And did he provide firearm props?
Yes.
And did you incorporate them into your music video?
Yes.
Was there anyone else featured in that music video?
No.
Okay. And if you did not have that, what I'm going to say is the firearm. When I say firearm, I mean the one that has a serial number on it and the one that is reported stolen. Okay. Otherwise, I'll make a distinction. All right. The firearm. Did you keep that between the box springs and the mattress for a particular reason?
Yes, I did.
And tell the jury what that reason is.
I'm sorry, go ahead.
Or what that reason was.
Okay, I used to pick my daughter up from school, so I put it on the bed so she couldn't see it or have access to it. They showed you a picture of it. It's a pretty heavy bed, so she wouldn't be able to lift it.
All right. So you kept it there for safety reasons?
Correct, to keep away from my child.
All right. Did you point that firearm at Ms. Clark?
I never had a firearm at Miss Clark.
Did you ever point it at Ms. Clark?
No,
Thank you. And why does the statement that you did not make sense?
because I didn't own a firearm when I was 8.
Okay. So you did not put the barrel of a firearm in her mouth?
No,
Did you own a lockbox for that gun, sir?
no.
Yeah. There was a second handgun. What do you know about that?
Yes, that was actually one of the props I bought myself.
So you purchased the item from one?
No, I bought it offline.
I see. Do you know whether the second one had a serial number on
No, it did not, because it's not real.
it? Okay. If you know, and if you don't, you don't. Is that firearm something that's typically called a replica?
Correct, yes.
All right. It's not real in the sense that it doesn't fire ammunition,
Yes, you can't shoot bullets out of it.
yet it looks like a genuine firearm.
Yes, it's metal. It looks just like one.
All right, thank you. Let's talk about the discovery of various items, including pieces of identification in a box in a drawer. Do you remember those photographs?
Yes, I do.
All right. One step at a time. What was that all about?
They just pretend ID and social security numbers.
You just pretend.
And
Pretend IDs and social security numbers.
did you place those items in the box they were found in? Do
No, I did not.
you know who did?
No, I do not.
My memory is that they were discovered at the Millstone address, grandma's house, is that right?
No, they were discovered at the 3872 Wilson Avenue.
3862, what avenue?
Wilson.
Wilson,
Yeah.
yes, okay. And at a time that you had moved into that location?
Correct.
What can you tell me as in terms of where they came from, how they got there, and so forth?
Yeah, so when I first moved in, they had cabinets on the wall, and on top there's like a dip where you could put stuff. So one day I jumped on my counter I was gonna put my gun up there because I was getting ready to go get my daughter from school. This was before I started putting it under my bed. So I put my gun up there and I seen a little box. I grabbed the box and that was in there, multiple checks, ID, social security numbers. So I think whoever lived there before had it up there and forgot to get it.
And what did you do with the items in that box, if anything?
I didn't do anything with items.
Other than move them from one location to another?
Yes, I was gonna throw them away, but I put them in my drawer.
Did you contact law enforcement, see if they could help locate the proper owners of those things?
No, I did not.
Was there a particular reason you did not?
No,
Okay. Did you use any of the items you found in that box? And in terms of putting them online, whether it's Facebook or something else, did you do anything with them?
no,
Okay. Did you, including attempt to sell, did you try to sell any of them?
no, I did not.
Have you ever been online at a website that where people can do self-identification information?
Yes, I have.
And do you recall when that was?
It was a couple weeks after I seen that box. I'm not gonna lie, it got me interested in, I guess, what people say scamming. So that's when I kind of got introduced to that. So yes, I've been on that website.
Was the purpose for doing, first of all, do you remember the name of it?
Telegram.
And was your purpose initially to inquire or to sell, or what were you thinking?
No, I was just curious. I was just curious about the whole concept of it.
And in order to use that, was it an application or what page or what was it?
Yes, it's an app you can download from the App Store. It's called Telegram.
All right, thank you. And did you do that?
Yes, I did.
As part of that, were you required to divulge some information, your name or your address, your email address, or things like that?
Yes,
And did you?
yes,
Okay. Did you also continue to use that app and try to sell or let people know that you had some items for sale? Items particularly pertaining to identification.
no, I never sold nobody's identity on Telegram.
All right. Thank you. You've testified about you and Ms. Clark having been at a place I think you called Max Bar. Was that the only time the two of you went there?
Together, yes.
Okay. Had you been to other locations where they served alcohol by the glass?
Yes, I have.
And did Ms. Clark accompany you on any of those other occasions?
Yes,
Was there ever any consumption of alcoholic beverages when the two of you lived in the same place, regardless of which one?
yes.
So in total, how many months do you believe that you and she lived together, regardless of where?
3 or 4 years.
Okay. Over that period of time, did you have occasion to make note of some of her drinking habits?
Yes,
And the photographs of her apparently with her eyes closed, unconscious. If you were there, are you able to tell us whether she consumed alcohol?
yes,
And if you were there, I think we've heard 2 different times, you provided the alcohol. Did you spike it with anything?
no,
Did you try to get her to a state of unconsciousness?
no,
Did she consume the alcoholic beverages voluntarily?
yes,
Is it true you may have purchased the alcoholic beverage?
yes.
Was there a beverage in particular that you can remember on that date?
Yes.
What was that?
It was Pink Amsterdam and Hennessy.
What is Pete Amsterdam?
This is what she drinks. It's Amsterdam. It's just pink.
Is it beer? Is it ale? Is it bourbon? I'm sorry?
It's liquor.
Okay,
I'm not sure what kind of
thank you. And what was the other thing you just told us about?
Hennessy.
What is that?
It's cognac, dark liquor.
Okay. And you were there and while she was consuming one or both of those, is that true?
Yes,
I'm not going to ask you which caused which, but is it safe to say that her unconsciousness occurred after she had consumed the alcohol?
yes,
Okay. Is that the same day that you took her into the bathroom and put the shower on and tried to get her to become awake?
yes,
Okay. During the time the two of you were together, did you possess something that you would have referred to as your dildo?
no.
Thank you. I beg your pardon. 10 minutes, please.
Okay, let's have a short break.
Well, necessary.
It's okay. Thank you. You may be seated, counsel. You may proceed, and sir, you're still under oath. Thank you.
Thank you, Your Honor. And I appreciate the great. Thank you. Mr. Brooks, I want to draw your attention to May 25th of 2020. May 25th of 2020. Do you have a memory today as to whether you and Ms. Clark were living at the same location on that day?
Yes.
And what is your memory?
2700 Robbins Road.
on that date, did you damage a door or a window causing you to be gain entry into that residence?
No, I did not.
Do you have a memory today as to whether on that date, Ms. Clark wanted to call 911 and report a crime and you prevented her from making that call?
No,
Do you recall being in possession of her phone at all on May 25th, 2025?
no, I don't recall.
All right. On or about May 25th, 2020, did you threaten to kill Ms. Clark?
Not that I recall.
Do you have a memory today as to whether you perhaps said that one or more times to her? I'll kill you if, or if you do this, I'll kill you. Use that phrase, if you'll kill.
Yes,
And when you use that word, were you intending to actually take her life?
no,
Were you intending to take her life if she didn't do whatever it was that you wanted her to do?
no,
Was it your position on May 25th of 2020 that she was either going to be with you or she was not going to be walking around anymore?
no,
Okay. You didn't take any acts toward killing her?
no, I did not.
Okay. And on May 25th, 2020, did you point a firearm at her?
No,
The firearm that we have in evidence that was in the box. If I understood your previous testimony, you possessed that firearm after the date of May 25th, 2020, is that right?
yes,
Is your cell phone back in 2020, 2021, the cell phone you had at that time, were you able to get on the internet?
yes,
And is it your understanding that if you could use a cell phone to get on the internet, it's a computer?
yes,
From time to time, did you use it in that capacity as a computer versus a phone?
yes,
It's your understanding today that law enforcement took possession of your cell phone and examined it?
yes,
All right. And as a result of that, did you become aware that, according to the detective who testified, there were several videos or images of you engaging with other women in sex acts? Do you remember that?
yes,
Okay. If you recall, were there more than 10 of those types of videos or images?
yes, probably around 50.
Okay.
5050.
Yes,
All of you engaging in one sex act or another with a woman?
yes, different.
So your first answer is yes.
Yes,
And were they a variety of women, different women?
yes,
Were you ever approached by law enforcement in such a manner that any of those other women were making any claims of criminal activity?
Your Honor, I'm going to object at this point as it calls for admissible hearsay.
Well, it depends. Let him finish his question, and then it could be a yes, no, without the hearsay.
Your Honor, just to repeat, I did not have the microphone on. People are objecting as it's inadmissible hearsay, as he is asking what officers may have told him, or what women may have told officers to tell him, which is multiple levels of hearsay. That's why it's inadmissible.
Well, let me see the question.
I'd be happy to.
Just a moment. I think you can rephrase and break it up without calling for hearsay. So, sir, I don't know what question he's going to ultimately ask, but you can't repeat what anybody else said. Does that make sense to you?
yes,
Thank you. Counsel, rephrase.
Thank you very much. Has anyone other than Ms. Clark made allegations of criminal activity as to you?
absolutely not.
All right, thank you.
We can approach.
Sure.
Absolutely.
Please remain seated, just a moment. Just stay seated, please. Thank you.
Excuse me.
Thank you.
Heard my intake of breath.
Yeah, I knew you were gonna do it. Thank you. Ready, proceed when you're ready.
Yes, thank you. First, I'm showing you what's been admitted as evidence People's Exhibit 53. Do you see it from where you're sitting?
Yes, I do.
And do you see a date? Do you see a date in the upper left-hand corner?
Yes, I do.
And what date do you see?
2/17/19.
Thank you. And toward the bottom, you see a portion of that form. It says problems addressed during this admission. See that?
Yes, I do.
And you see where underneath it says supervision of other normal pregnancy. Can you tell us if Miss I could find this say correct. Was she pregnant at the time?
Yes, I believe she just had that pregnant.
All right. And I don't want any details whatsoever. Generally speaking, was there problems with that pregnancy?
No.
And then underneath it says domestic violence of adult. You see that?
Yes, I do.
Do you see anything that might more particularly describe what's written there? You see anything on that form that says what act of domestic violence?
No, there's nothing said.
Okay, thank you. I want to just touch on this one more time. You said, I believe your testimony was that your relationship with her was intimate, it was a romantic relationship.
Yes,
Okay. Did you ever engage in a sexual act with her when it was obvious to you that it was not consensual?
no, absolutely not.
Did you perform any sexual acts on her while she was unconscious or sleeping?
No,
If you recall, can you give us a month or a year that you contacted the Lansing Police Department?
yes, it was 8/21/24.
2024. And you were successful, at least to the extent that you contacted them and spoke.
Yes,
All right. This, without telling me what she said, do you have a memory today as to approximately when the issue of PTSD came up between you and Ms. Clark?
no,
Can you tell us whether it was closer to the beginning of your relationship, the middle, or toward the end? And you came to an understanding that she was of the mind that she was suffering from that at the time you two got together?
yes, my first name.
Without telling me what she said, did she give you an idea of her childhood growing up?
Yes,
Did Ms. Clark ever say to you or threaten you or about getting you put in jail?
yes, multiple times.
Help me understand that in context.
She made a false police report on me back in 2018. And I was talking to my lawyer about it, and he told me if I wanted to press criminal
Your Honor,
charges.
this time I'm going to object because he's now trying to get hearsay from his lawyer, which is a whole mess of other issues.
Sir, you can't repeat what somebody else told you. Thank you. Justice Dane.
So the first question is whether, and I think you said yes.
Yes,
And I asked why, or no, excuse me, when. And you gave me the year 2018.
18.
Thank you. I want very briefly to show you again what's been admitted as People's Exhibit 16. Now I'm looking at page 7, and when I put it on the viewing screen here, I want you to see if you can determine whether this was from a just a screenshot of something or whether it was a screenshot of a video. Okay. Can you tell?
Zoomed in.
Oh, sorry. You see that?
Yes, I do.
What is it about that that causes you to be able to say one way or another?
It's a screenshot of the video with the play button,
With the what?
with the play button in the middle of the picture.
The play button, is that what you're saying?
Yes.
Thank you. You can stop or start it. Thank you. Thank you very much, Your Honor. I pass the witness.
Thank you. Cross,
Yes, Your Honor. That's okay, I'll make do. Good morning. I want to start by trying to get a good picture here. When do you claim you moved into the Eaton Rapids Road address?
Around 2020 or 2021.
Are we talking when you say that, do you mean the end of 2020 through the beginning of 21? That's kind of the range you're guessing?
Yeah, one of the years.
Okay. So, are you saying it's you moved in there at any point in the year 2020 or 2021?
Yes.
Okay, so it could be any time in those 2 years that you moved in there.
Yes, I think so.
Got it. So when did you move out?
Right before the winter time. Right, I'll say probably around October.
Of what year?
I'm not sure, 2021.
Okay, so you're saying you moved out before the winter, so let's charitably call that the fall of 2021. Is that correct? Okay. Didn't you say on cross-examination you only lived there for about half a year, 6 months?
6 months.
Okay, so working backwards from the fall of 2021, that means you're saying you moved in there at the beginning of 2021, correct?
No, I don't remember what year.
Right, but you know that you moved out in the fall of 2021 and you were there for 6 months, right?
Yes.
Okay. What month of the year is October? This is not a trick question. What month of the year is October? What number?
I don't know.
Count it out. Use your hands. Please tell me what number month of the year October is.
10.
Okay. What month is 6 months before that? What's 10 minus 6, sir?
4.
Okay. What's the 4th month of the year?
April.
Got it. So, are you saying that you moved in sometime around April 2021?
Or 20. One of the two, I don't remember the year, as I said.
Okay, so now you're saying it's possible you moved out in October of 2020.
Yes, one of the two.
Okay. So that means you weren't living there in 2021 when the surveillance video was being taken.
Yes, when the surveillance video was taken, I wasn't living there.
Wasn't?
Yes.
Well, that's interesting because you testified in cross-examination. You were living there. She just wasn't letting you in.
No, I was trying to get my clothes, the rest of my clothes. That's the reason for me going there. I already got left.
So you're saying you had left in October of 2020 and you came back in 2021 to get your clothes.
No, I'm not putting it. It's one of the years, 2020 or 21. I don't know which one.
You're saying you don't know, being there on the witness stand, what year you lived there.
Correct.
So you, right now, are saying you do not know if you were living there in 2020 or 2021.
Yes.
So you are saying, in your sworn testimony, you don't know if you were living at Eaton Rapids Road in May of 2020.
Right.
So you actually are telling us you could have potentially not been living there on the date of the home invasion.
No, there is no home invasion.
May 25th, 2020. The day that you've been saying throughout this trial, throughout your testimony, you lived there. You're not saying it's possible you didn't.
Correct.
Okay. So you have no personal knowledge about whether or not you lived at Eaton Rapids Road on May 25th, 2020, correct?
Yes, I moved out in 2021, so it's both years.
Okay, so now you're saying you moved out in 2021,
Yes,
the fall of 2021.
yes,
You were there for 6 months.
yes,
Great, so your testimony is that you only lived there from the spring of 2021 to the fall of 2021, correct?
yes,
So your testimony now is that you were not living there in 2020, correct? You know what? We can move on.
yeah,
You testified that the firearm that was found under your bed at Wilson, you had no idea it was stolen, correct?
yes.
How'd you buy that gun?
Somebody from the streets,
Who?
I'm not saying,
Oh, you don't have that option, sir. Who sold you that gun?
I don't recall.
So you don't remember where you got this gun from?
No,
Do you remember the process that you went about in purchasing that firearm?
no, I do not.
Did you get that firearm registered in your name?
No, I do not.
Have you ever bought a gun before?
Yes,
When?
2019.
2019. Did you also buy a gun in 2018?
No,
No?
or it would be 2018 would be when I purchased it. It would be 2018 when I purchased firearm.
Objection, Your Honor. There is no question before the witness. And I would appreciate it if counsel would indicate pistol type handgun or a long gun.
I can absolutely clarify that. What type of gun did you buy previously?
I think it was a 380
Are we talking a handgun or a long gun?
handgun.
Handgun. Where'd you buy that gun from?
Bigger than you?
Dicker and Deal.
Yes.
What was the process of getting that gun?
Background check?
Anything else?
No.
Did you get that gun registered in your name?
No.
No? Didn't you tell officers on November 4th, 2018 that the gun was registered in your name?
Yes, I thought it was in my name because when I purchased it, they gave me a slip with my first and last name with the serial number on it, so I'm gonna keep it on my personal.
Did you get any such slip from your friend on the streets?
No, I did not.
Did you go through a background check for the gun you purchased from the friend on the streets?
No, I did not.
Isn't it true you knew what the proper procedure is for purchasing a firearm in the state of Michigan because you did it in 2018?
No, I did not. That's why the firearm was taken from me. I didn't know the process.
In what way?
They took it and said that when you buy it and they give you the slip with your name and serial number, you're supposed to go downtown and get it registered. I wasn't aware of that.
Well, isn't it true that actually you thought you had a CPL and you were transferring it in a vehicle?
No.
No?
No.
No. So, you've got two firearms that were found, correct?
Yes.
The one in Millstone and the one in Wilson, right?
Yes.
But the one in Millstone, that wasn't a real gun. That's your testimony now.
That's been my testimony.
People's 26. You're saying that's a prop gun.
Correct.
Correct. Where did you keep that?
That box right there.
That box. And where was that box?
In the closet, hidden under clothes.
What can you tell us about that box?
That box, it's an extra box a friend had. It's a Glock box. Gave it to me.
And what is a Glock box?
It's just, you could put anything in there that's a firearm or anything, actually.
Does the box lock?
Yes.
People's 25. Is that the lock?
That it came with, yes.
Is that the lock around the handle of the box?
With the key in the lock, yes.
You could have taken the key out, right? And kept the key and the lock separate,
No, the key was jammed in it. It was stuck in.
jammed in it.
Yeah.
So there was no way that you could possibly use that as a gun box. That's your testimony.
I never said that. I
Could you
said-
use that to safely hold a firearm?
No, not safely because the key was jammed in there.
And there's no way you could get that fixed, right?
No, I tried to take it out. It wouldn't come out.
Could you have bought any other lock and replaced that one?
Yeah, if I had a real gun, I was trying to keep and that like just hidden.
Got it. So if you had, in what you literally just said, a real gun that you wanted to keep hidden, you could have gotten any other lock in the world and put it around that box to keep it safe. That's what you just said, correct?
Yeah.
Great. Your testimony is you hid the stolen firearm in your mattress to keep it hidden from your daughter, correct?
I never said the firearm was stolen.
The firearm that's been proven to have been stolen, your testimony is that you hid it in your mattress to keep it away from your daughter, correct?
That's the reason under my mattress, yes.
Great. When you had a gun box in your closet at your grandmother's house, correct?
Yes, it doesn't lock.
And as you've already testified, you could have bought any other lock in the world to have that be a functioning gun box to keep a working firearm hidden. I believe keeping it hidden was your exact words. Isn't that correct?
Yes, that already happened.
Thank you, sir, for your answer. Many of my questions are yes or no, and only yes or no. Do you understand?
Yes.
Thank you. So, you did not use the gun box that you had in your closet at your mom's house to keep safe and hidden the working loaded firearm at the Wilson address.
Ask the
Correct?
answer, Your Honor.
I'm
Objection.
sorry, what? What's the objection?
Asked and answered. The witness has testified that he didn't keep the actual firearm in that box.
Response?
I can happily move on.
Thank you, move on. Sustained.
Given that you had gone through the normal legal process of purchasing a firearm back in 2018, had interactions with law enforcement who clarified for you what steps you are saying you didn't understand about it back then. When you bought this gun off your unnamed person that you refused to name on the street, did you find it suspicious?
No, I did not.
Got it. In 2024, November of 2024, did you have an interview with Detective Brandon?
Yes.
Did you discuss firearms?
Yes.
Isn't it true you told Detective Brandon that you do not have any firearms and that you have never had any firearms since your incident in 2018?
I was high. I don't remember. I remember talking to her, but I don't remember what you said.
So you don't remember, you remember having the interview, but now
Yes.
you're saying you're not going to be able to remember a single thing you said during it.
No, I was under the influence.
Great. So you don't remember telling her there would be no firearms found at the Wilson address.
That's probably something I did tell her. Yeah, I'm sure.
Would that have been a lie?
Yes, it would have been a lie.
Why did you lie to the detective?
I was under the influence. I'll be lying if I told you why.
Say that again?
I was under the influence. I'll be lying if I told you why I told her that. I don't remember.
So do you frequently lie to law enforcement?
I'm not in contact with law enforcement at all.
Of course. You definitely didn't lie to the detective to try and get out of trouble, right?
I don't remember.
Don't remember.
No. Do you have it? Can I read it?
Objection, Your Honor. There is no question before the witness.
Sir, your attorney will get another chance with you, and right now, counsel's asking yes, no questions, so please answer it yes, no, I don't know. Thank you.
There was a preliminary examination hearing on December 19th, 2024. You were there for that, right?
I don't recall.
Were you sitting in a courtroom at the defendant table with your lawyer throughout a hearing in front of Judge Flores on December 19th, 2024?
December, yes.
So December 19th, 2024, you were at this preliminary examination, right?
Yes, I was.
You heard testimony from Alyssa Clark, correct?
Yes, I did.
And your testimony on Tuesday to this jury is you never heard claims about a video where you violated her unconscious body until a week before trial, correct?
No,
No, that's not your testimony to this jury?
that's not the testimony.
Why did you say that on Tuesday then?
I didn't say that was Tuesday. I said when she's claiming I put a gun in her mouth, I'm just not hearing about that.
I'm just not worried about that.
When she said I put a gun in her mouth, I'm talking about that. That's what I was referring to.
He said, I'm just now hearing about that. You may
Yes,
proceed.
So your testimony is you didn't say in explicit detail to this jury that you found out about the claims of a video until a week before trial when you were reviewing your discovery.
yes, that's correct.
You're claiming that you were referring to the gun being put in her mouth. That's what you found out about a week before trial while going through your discovery.
Yes,
Okay. Except didn't you also testify that the first time you heard about the gun in the mouth was while she testified in this trial on Monday?
yes, there was some alluding to a firearm in her, in the discovery that I read.
Sir, are you telling me that the claim of you putting a gun in her mouth was in your discovery prior to trial?
I don't recall.
Don't recall. Do you have memory problems, sir?
No,
No. Why are you having difficulty remembering what happened on Tuesday?
I'm not.
No, of course not. You testified today that when Alyssa moved out of Millstone, she went to her cousin's house, right?
Yes,
And then to Eaton Rapids Road.
correct.
Except you testified on Tuesday that she went to her mom's house and then Eaton Rapids Road, right?
No.
No. You definitely didn't testify to that on Tuesday.
No,
So it wouldn't be in the transcript.
no,
Got it. You testified on Tuesday. Alyssa Clark is a person who would call the police. If I had choked her, she would have called the police and I would have been in jail, right?
correct.
That's still your testimony, right?
Yes,
Great. Weren't you arrested and charged with strangling Alyssa Clark in 2019?
I don't recall.
You don't recall being charged and arrested for strangling her?
No,
No. Would being arrested for a crime stand out to you in your memory?
not from 7, 8 years ago, no.
But you testify with absolute certainty. No other woman has accused you of criminal behavior before, right?
No, he asked if any woman has accused me of sexual criminal behavior.
No, he did not. He did first. And then he asked, has any woman before Alyssa accused you of criminal behavior? And you said no. Is that true?
No,
It's not true that that is what your defense attorney asked you.
Objection, Your Honor. I inquire of some more specificity.
I can clean it
The
up.
question was,
I'll clean it up. Thank you.
Thank you.
You may proceed.
Given that the transcript absolutely shows that you were asked, has any other woman accused you of criminal behavior? Let me ask it, has any other woman other than Alyssa Clark accused you of criminal behavior?
criminal behavior, yes.
Who?
Emily,
Who?
girl named Emily,
Girl named Emily. Is that it?
yes.
Who is Ivana Andrews?
Right,
Her friend. How do you know Ivana Andrews?
through Facebook.
Through Facebook. That's the only way that you know her.
Yeah, that's how I met her, correct?
Who is she to you at this moment?
She's the mother of my child.
Great. Was she the mother of your child back in June of 2017?
Yes,
Didn't she also accuse you of assaulting her on June 19th of 2017?
yes, she accused me of it.
So when you said the only other woman who's accused you of crimes was Emily, that wasn't true, correct?
I didn't remember that because it never happened. I never got in trouble for that situation.
Sir, weren't you charged with domestic violence in that as well and arrested for that as well?
I don't recall.
You don't recall having multiple other criminal cases where you have been charged and accused of domestic violence against the mothers of your children?
No.
No. So there could be dozens and you wouldn't remember.
If there were dozens, I would remember 100%.
Okay, so what number of criminal cases accused by the mother of your children are you going to suddenly start remembering they exist? You said dozens, so would you remember 11 of them?
Yes, for sure.
How about 10 of them?
Yes,
9,
yes,
8,
yes,
7,
yep,
6,
yes,
5,
yes,
4,
yes,
3,
yes,
2.
no,
Okay, so if there were 3 cases, then you'd remember.
yeah, yes,
I'm sorry.
yes,
That's your testimony to this jury.
yes.
That if there was just one more time you had been accused of beating the mother of your children, you would have remembered them.
Yes, if I was in jail.
Thank you, sir. Thank you very much. Now, you were shown by your counsel many exhibits of text messages between you and the victim that have already been admitted at trial, correct?
Yes,
Okay. And for some of those, you said, yep, I remember those. Those are right, right?
yes,
And then one of the last things you said in your direct examination were, the other ones, you're not disputing them, you just don't remember them, correct?
yes,
So, for the ones that you don't remember, you're not saying they didn't happen, you're just saying you don't remember them happening, right?
no, I don't have no knowledge of them at all.
So you're not saying that these didn't happen.
That's what I'm saying.
You're not saying that you didn't send these messages.
That's what I'm saying.
Okay.
Your Honor, I'm sorry, that's confusing again. You're not saying not, it's double negative if they could get ironed out a little straighter, thank you.
Your testimony is that these are real, you just don't remember them, correct?
No, I don't recall none of them.
Now you don't recall any of them. Is that what you're saying?
Yes, the ones I recall, I admit I recall. So.
But the other ones that you don't remember, you're not saying they didn't happen. You're just saying you don't remember these happening. Is that right?
I'm saying they didn't happen.
So now you're saying you know for certainty that these other ones didn't happen.
Yes, that's not new text.
It's not what?
That's not new text.
You're now saying, not that you don't remember them, but that these are just completely fabricated lies.
Yes, the ones, yes.
Except for the ones you like, right? Those are real?
I don't like none of them.
No?
No.
But the ones that you think help you, those are definitely real, and you definitely remember them, right?
Yes, because they actually happened.
Have you threatened to kill her before? Have you texted Alyssa Clark, bitch, I'ma come kill you tonight?
I don't know what manner I have threatened her though.
Do you remember saying those words?
No.
People's 14. Bitch, I'ma come kill you tonight. Say goodbye to the girls and that baby. You know you dead, bitch. Now goodbye.
Yes.
Did you send that to her?
Yes.
Okay. This photo of her, you took that, right?
Yes.
Your testimony has been that she just drank herself unconscious, right?
I never said that. We were drinking, huh?
So you guys were drinking.
Yes.
Did she just go to bed or did she fall unconscious from the alcohol?
She was throwing up. She was throwing up now. She didn't just go to bed.
Sir, is your testimony that she became unconscious in those photos to the point where you had to bring her into the shower to wake her up from drinking, or she was just went to bed and went to sleep?
Yes, drinking.
Okay, so that's your testimony. Did you guys have sex that night before or after the drinking?
No.
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 Did you take your clothes off?
Yes.
Okay, so you took her clothes off.
Yes.
And then, between her going unconscious and you waking her up under the shower, you took what you're claiming are photographs of her body unconscious. Is that true?
When she was sleeping, yes.
Do you frequently take photographs or videos of unconscious women?
No.
No. Did you have any reason to take photographs of her that day while she was unconscious?
Yes,
What was that reason, sir?
because she had a video of me getting out the shower, so I was just being petty,
Just being what?
taking the pictures.
So because she had a video of you naked, you are claiming you took these photographs.
Yes, because she had posted it before.
How many videos of your penis are on your phone?
What do you mean? Like sexual videos?
Yes.
Probably like 50.
You're with other people in these?
Yes.
Have you sent them to other people before?
To them, yes.
Are any of these ones that would cause people in your life to look at you in a different light if they were to come out?
No, I mean, I did a couple of OnlyFans videos with some women that like it's kinky stuff, but no.
In what way?
People would pertain to like, hey, can you make a video of this? I pay this dollar amount.
Kinky in what way, sir?
Kinky, like, there was one guy who paid this girl $1,000. She said just have somebody have sex with you with a firearm pointing at you from behind. So kinky in that way.
So other people had these videos, right?
Yeah, she sold it to the guy, yes.
And you were so concerned about a photo of you getting out of the shower that your testimony is you took what you still claim are photos of Alyssa after she was vomiting on herself, according to you.
Oh, yes, for sure. I wasn't in the video. It's just my penis.
Right.
You would agree that your penis is attached to you, right?
Yes, I was.
So isn't that you, sir?
Isn't that me what? In the video?
Well, your penis is you, isn't it?
Yes, but you couldn't
Okay,
tell
that's
me
it.
that.
So you're claiming this is a photo you took.
Yes,
And this is a photo you took.
yes,
And that this is a photo you took.
yes,
And that this is a photo you took.
yes,
Those are your fingers. Correct?
yes,
She is unconscious, correct?
yes,
And your claim is still that this was not from a video.
correct.
Your testimony is that anytime you take a screenshot from a video, it will show a play button or the reel at the bottom, right?
I didn't understand fully. I just explained to my knowledge, yes.
And that's your testimony, right?
From a video, yes, usually.
Great, thank you. How many videos of you and Alyssa having sex have you taken?
I'm not sure. You,
A few.
yeah.
Didn't you tell Detective Bramman there's only ever been one? And that you had deleted it?
I don't recall.
Do you recall telling Detective Bramman that you deleted it because you were dating a new girl and you didn't want her to see that? Out of respect for her.
I don't recall.
Don't recall.
No.
Hey, would you be worried about the person you're in a relationship with seeing a video on your phone of you putting a firearm into a woman's vagina?
No.
You wouldn't be worried about that.
No.
You think that your partner would have absolutely no concern seeing that.
I wasn't dating nobody at that time.
But you were at the time that you had the interview with Detective Bramman, right?
I don't recall.
Were you in a relationship with anyone November of 2024?
No.
No?
No.
No. When'd you start dating Minnie James?
I never actually dated her.
So your testimony for the last several days hasn't been that you were dating Minnie?
No, not at all. I slept with her best friend. That's what I said. I never used the word date.
All right, sure. When'd you sleep with Minnie?
I don't recall.
No.
No.
No. Didn't you testify that all of this is because you were dating Minnie James?
That I slept with her, yes.
And that it happened 5 years ago?
Yes,
What was 5 years ago, sir?
21.
When did you sleep with Minnie James?
I know it was around winter time.
Would it be 2021?
Yes, it happened, yeah.
Okay, so now you do recall that it was winter of 2021, right?
Yes, it was winter time.
Great, I'm so glad we were able to work through that for you. Thank you. Didn't you tell Detective Raymond you were actively dating Minnie James during your interview, November 2024, and that you have a child on the way?
I don't recall.
Don't recall.
No.
You don't recall telling her that you've been dating since the spring of 2023?
No, I don't recall. I probably was lying to her.
Probably were lying to law enforcement, but you're definitely not lying to this jury, right?
Correct.
Right.
Is this a good time for a lunch break? Or are you nearly finished?
I'm not nearly finished. This would be a great time for a lunch break.
Great, lunch has been delivered, it's time for break.
Thank you, Your Honor.
All right, we are back on the record. Jurors, please, unless there's some preliminary matters.
No, yeah, people.
Not at this time, Your Honor, from the defense. Thank you.
Thank you. Proceed, sir. I'll just remind you, you're still under oath, and counsel, you may proceed.
Thank you, Your Honor. So your testimony has been that you do not remember what you told Detective Bramman in November of 2024 because you were high that day, correct?
Yes.
Were you high on Tuesday?
I don't know.
You don't know if you were high on Tuesday?
Oh, you're no.
Okay, so your first day of testimony, you weren't high then, right?
On Tuesday.
You were not high that day, correct?
Yes.
Okay. Now, your direct examination from today, you made a point to specify that it was Eaton Rap Troves is our house. It was our house, calling it our house, our place. Is that right?
Yes.
Is that because you realized after your testimony on Tuesday that for that entire day, you referred to that location as her house, her place?
No, it never even crossed my mind.
No. Do you remember referring to it the entirety of your first day of testimony as her house and her place?
Yes, I do.
Okay. Is it true that you, throughout your entire hour and a half interview with Detective Bramman, when asked extensively about where you have lived over the years, never once said that you resided at Eaton Rapids Road?
I don't know what I told her.
Don't know. Safe to say you're having a difficult time remembering a lot of things, right?
No.
No, you're saying that you're having a good time with your memory?
Yes.
How many times do you think you've responded with, I don't remember, I don't recall, today alone?
I don't know.
No, can't remember, right? All right, let's see what you do remember. People's 9. From May 6, 2020, do you remember texting Alyssa, I'm be getting all my shit through that window I unlocked too? Do you remember texting her that?
No, I do not.
Do you remember texting her, bitch, you're through? On God, you want to play? I'm gonna fuck your life up.
No, I do not.
Okay. Let's move to People's 10, May 18th, 2020. You don't remember texting her and beating your ass, right?
No.
Do you remember texting her, don't make me kick that motherfucker in?
No, I do not.
Do you remember texting her, bitch, I'm kicking the door in. I put that on my kids and everyone dead. I'm done talking. I'm around the corner. Do you remember texting her that?
No, I do not.
Do you remember texting her, you better not have my baby out and Mercy better be on the way or I'm fucking kill you. I put that on the Bible, bitch. Don't play with your life.
No, I do not.
No. Do you remember at any point in your relationship threatening to murder her and saying, I put that on the Bible?
No.
No. People's 11. You remember texting her May 25th, 2020? I'm smacking the fuck out of you, bitch.
No,
How about I'm gonna kick this bitch in and break everything?
no,
In your testimony is nothing happened on May 25th, 2020. In your words, there was no incident, right?
I don't know.
You don't know?
I don't know.
So on direct examination, when you said, in response to your own counsel's questions, was this from May 25th, 2020? You said there was no incident that day. Do you remember saying that before the lunch break?
Yes,
Okay, was that true? Did no incident happen on May 25th, 2020?
yes,
So then why did you just say you don't know if any incident happened on May 25th, 2020?
I wasn't listening to the dates, I'm sorry.
How frequently throughout this trial have you not been listening to the questions that have been asked of you?
That's the only time.
Only time, got it. May 25th, 2020. Do you remember receiving a text from Alyssa Clark? The police came earlier and seen me through the window. They said somebody called and they said they seen me run from this house bleeding. Do you remember receiving that text?
No,
No. Let's go to People's 12. Now, you testified on direct. You do remember these text messages. Isn't that right?
yes,
Got it. So you remember texting Alyssa, after I beat your ass, you begged me to stay, bitch. Right?
no, I don't remember those dates.
Okay, so now your memory has changed since before lunch.
No, it hasn't.
Are you high now?
No,
Okay. Do you remember texting Alyssa, you see what I said, this for life, only way out is death? Do you remember texting that?
yes,
Yes. So you have told her the only way out is death, right? But that's not a threat, right?
I never said that.
Didn't you say in response to questions from your own counsel, yes, you had said, I'm gonna kill you, but it wasn't threatening?
I didn't take act upon the threat, is what I said.
That's not my question.
No,
Is that a threat?
no,
No. This isn't a threat. Your testimony is, this is not a threat that if she were to try and leave you, she would be killed.
no,
Great. This is from that same exhibit that you said to your counsel, you remembered these messages. Do you remember? Alyssa texting you, when I pop up dead, I hope that shit haunt you for life. Because at this point, I'm going to do what I got to do to get out. I can't take it anymore. And you reply with, shut the fuck up. I said I ain't going nowhere. You know this. I said I love you. Do you remember these text messages?
no, I haven't seen you much.
You did not see these text messages
Not that-
on Monday?
No,
You definitely were high on Monday, right?
right,
So you did not see these put on the big screen, on the screen right by where you were sitting, and me read them aloud, line by line. You don't remember that.
no, I was taking notes.
So you don't remember from Alyssa's testimony in this trial. Is that what you're saying?
I don't remember that page you just showed, is what I'm saying.
Oh, of course not. How about this one? Do you remember? I said you mine for life, and you know this. I don't care what the fuck you think this is. You know it's death to get out, so take it how you want. Do you remember sending that text to her?
No,
And I guess I now have to start asking, do you remember this text being admitted and read on Monday?
no,
No. Tell you what, Your Honor, if I could approach what's People's 12?
Sure.
Since you don't remember this ever being admitted or read, you go ahead, look through each one of those pages and read them to yourself. Since this will apparently be the first time you ever see it. And you let us know when you're done. Oh, don't go quickly, sir. Leave. Sir, You're done in 20 seconds reading a 14-page document?
No, I recognize the French. I just didn't see those exact pages. I was like.
Great. Read them.
Oh, wait a minute. Let's not waste time. We don't need to. Sir, do you remember writing those?
Yes, I remember.
Okay. And you remember there was a lot of testimony?
Yes,
And there was a lot of testimony about the emails, and they were actually put on the evidence screens, correct?
yes.
Okay, so are there any you need to review before you answer the questions?
No, I just see them up there.
Okay, so if you don't remember and counsel's asking you a question, they're right there, flip through them before you answer, is that fair?
Yes.
We'll save some time that way, counsel, if you don't mind.
I need to have them back for
You
this.
can have them back and then
Thank
you
you.
can have you hand him whatever it is if he doesn't remember. Thank you.
Thank you.
How about this page? Do you remember texting her, go back home or I'm pulling up, and telling her, I said it ain't over till you're dead. You know I'm dead ass serious. Didn't I say go home? Do you remember texting her that in September 16th of 2020?
No, I do not.
Do you remember texting her, bitch, I own you. You're my property?
No.
Do you remember ever saying to Alyssa, bitch, I own you. You're my property?
No,
No. Did you ever put a GPS tracker on Alyssa's car?
no.
Did you tell her you would put a GPS tracker on Alyssa's car?
Yes, I did.
Why did you lie to her about putting a GPS tracker on her car?
Because she did something that she had my location on my phone, so I just lied to her, said I had her location.
And what was the point of that?
Just basically, like, you know what I'm doing where I'm at, I know what you're doing where you're at also.
And why was it important to you that she knows you know where she is at all times?
Because she knew exactly where I was.
She knows what?
She knew exactly where I was.
It wasn't to make her afraid that you could come find her at any point, right?
I mean, no. That was it. No.
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 It wasn't so you can send texts like, you broke ass ain't out there. Your car won't even make it, bitch. I see where you're at right now, fucking clown ass bitch. Now I'm really coming to beat your ass. It wasn't so you could make her afraid with that, right?
No.
No. Do you remember texting her, come out before I take this battery and jump through this window?
No.
No. Because you definitely didn't take her car battery, right?
Correct.
Correct. Were you lying to her then too? Threatening to take a battery like you were lying about the GPS tracker?
Those aren't my texts.
Those aren't your texts. Of course not. These are, you're saying these are fabricated, right? Mr. Brooks?
Yes.
Got it. Did you text her, bitch, I'm by your car. What don't you get? I got GPS. Come the fuck out or I'm breaking this bitch. Bitch, this is my last time telling you on my kids. You text her that?
No.
Would you frequently swear on the lives of your children that you were going to assault Alyssa Clark?
No.
No. People's 13. Did she text you November 1st, 2020? You could have left me brain dead today, and you reply with, baby, I know, I'm so sorry. Did you text her that?
No.
So this of you admitting to nearly killing her November 1st, 2020, that's all fabricated, right?
Yes, that's not for my fault.
And you never sent or received these, right?
Correct.
Now, in 2023, you were charged with the harassment about the posting of the messages. Is that right?
Yes.
Isn't it true that while there's no contact order in place in 2024, you texted Alyssa this very long string of texts about tell my babies I said happy birthday and I love them?
No, I did not. That's not my memory.
No. Isn't it true that you, when she kept blocking you, would use text now numbers in order to be able to contact her?
I have one text now number. No, not to contact her.
You did not use text now numbers to contact her.
We talked on it, but I didn't make it to contact her.
Have you
No.
contacted her over text now?
Yes.
What is your text now number?
Text now number was 517. I don't know.
Wait, let me just stop. What is a text now number? Is that different than how we text on our phones?
Yes, ma'am.
What is it?
You can download the app to get a new number.
Okay, so you use it on your phone, but it's not your number. You download a separate number, and that's called text now.
Yes.
Can you download as many numbers as you want?
I'm not sure.
Okay. And you had a text now number?
Yes, I did.
Okay, thank you. Thank you.
So you don't know what your text now number was, but you know for a fact it wasn't this one, right?
Yeah, I didn't have 616.
No, of course not. Yours was 517, and nothing else, right?
Yeah, it started with 4, but I don't remember the exact number.
Start with a 5 or a 4?
4.
A 4.
Yes.
The area code or the phone number?
The phone number.
One moment, Your Honor. It's going to show people 16. Now, you've already said these texts are real, right? These are from September of 2023 in regards to the posting.
No.
No, so now it's not real anymore. It was real when Mr. Freeman was asking you about it for about, I don't know, 45 minutes. But now that I'm asking the question, this isn't real, right?
Can you pull it down a little bit? Yeah, I don't know.
So now you don't know if this is real. How about this? This here. You sent her the social media metrics from your posts, right?
Okay, yeah, I remember now. Yep.
Okay, so these were you.
Yes.
Hey, that's a text now number, right?
No, it would be purple. It would pop up green like an Android on my iPhone.
Are you saying that number is your cell phone?
No, it was a friend of mine.
So you used a friend's phone to contact her.
Yes.
Did you do it with the other one too?
No.
No. Definitely not then, right?
Definitely not.
Definitely not when there was a court order in place saying you're not allowed to talk to her, right?
Definitely not.
Like you said, that you wouldn't do that. A court order would stop you. You definitely wouldn't violate it, right? Right. You sent her the video of her giving you a blowjob, right?
Yes.
This is you.
Yes.
You want to play bitch, it's up. Now you got me started. What do you mean by it's up?
It's just a firm basically saying like,
You mean it's uploaded, right?
no, it's up like, basically I'm gonna be on some bull ass like you are on. That's what I'm doing.
Really? So it wasn't in reference to you all over the Reddit, bitch?
No.
No. Hey, what's Reddit?
Reddit is, it's another app, you know.
Describe it.
They got social media posts on there, breaking news.
You can post things anonymously on Reddit, correct?
I'm not sure, I never posted on Reddit.
Really?
Yes.
So this here of you saying you all over the Reddit, bitch.
Yes, that was a lie. This was an attempt to get her to take that video down as well.
So everything that's incriminating, those were lies you said, right?
As far as what?
The GPS, beating her, posting her naked photos on Reddit. Everything that you admit you've done, if it's incriminating you, it's a lie, right? Then you're lying, right?
I'll never do none of that, no.
No. So if it's incriminating, it's a lie, right?
No, I've already admitted to things, understand. That is incriminating myself.
Really?
Yes.
Sir, when you talk about yes, I was accused of domestic violence before, I was arrested of domestic violence before, well, then it was, no, those were false reports, right?
Yes, I was arrested.
And they were false reports, right?
Yes, I wasn't sentenced, charged with anything.
The claims were false. First of all, are you saying you weren't charged with anything?
Yes,
There were criminal cases where you had to appear in court because you were charged with crimes against the women you had children with? Is that your testimony?
I mean, like, I didn't get in trouble for none of it, is what I'm saying. I was charged with it, but they got dismissed.
Right. You threatened them not to come to court, right?
No,
So they were dismissed when they didn't appear, correct?
yes,
Right. So those were false reports. But then you said, oh no, I have put my hands on Alyssa before. You said that, right?
yes.
And each of those times, well, I wanted her to leave, she wouldn't leave, so I pushed her out of the house, right?
Yes.
Such immense admissions you're making there, sir. My God. You're trying to say, well, I've definitely done these things, which means I'm honest when I'm saying here, I didn't commit these charges, right?
False.
That's the only reason you're willing to say you put your hands on Alyssa in any way, shape, or form, correct?
False.
False. You testified on direct examination. You magically found a box of fraud in the apartment you got, right?
Yes.
My God. And then you didn't do anything with it. You didn't post any of it online, right?
I said I was looking into it, yes.
No, you testified that you did not post anything that you found in that box online. That's what you testified to this morning. Is that still the truth?
No identities I testified to, yes.
I'm sorry, say that again?
No identities I testified and said I didn't sell. I was asked if I sold identities online. No.
You were absolutely asked to post anything online, but since you disagree, I'll ask it now. Did you post anything from that box online?
The video you guys seen, but not individual IDs or social, so no.
It was 55. The Telegram list. That's you posting that, right?
That wasn't in the box, but yes, that's me.
Okay, so you definitely didn't post from the fraud box. You just posted other people's credit cards, right? Yes or no? Yes or no, sir?
I said correct.
Did you put Alyssa Clark's ID and social security card in the fraud box?
Yes, I did.
Yes, you did. But you definitely weren't trying to commit fraud when you posted on Facebook, got a good ID to sell for $100.
No, definitely not. Absolutely.
Definitely not, because no one hit you up in your inbox, right? That was your answer earlier this morning?
That and I wasn't going to sell it.
Right. Definitely.
Correct.
Of course.
Definitely.
If I could switch to the HDMI, please.
Hey, guys, niggas be doing the same shit, bro. I'm saying, niggas got the evidence. You know what I'm saying? Niggas just ain't got no good food right now, man. That's all it is. Niggas do this shit, bro. That's what I'm trying to tell you.
Why'd you post that?
I didn't post it. That was sent to somebody.
Why'd you put it into a Telegram chat?
It wasn't a chat. It was just between me and one other person.
Hey, is a chat a conversation between people?
I don't know.
Why'd you send it to someone on the Telegram?
I don't know.
You don't know. Would looking at a copy of the Telegram log help refresh your memory about why you did this?
No.
No, of course it couldn't. It's not because you don't want to actually answer, right?
I already said. I said I was looking into fraud and stuff. I don't know what you want.
I would like to know why you posted the box of fraud of other people's social security cards, driver's licenses, and credit cards to a Telegram account where you were talking about committing identity theft. Why did you post this?
I don't know.
And looking at the log between you and the other person wouldn't help you understand why, right?
No.
No. different question then. Why did you decide to have your username on these Telegram chats be Scam Man?
Something I seen on Reddit.
Something you've seen on Reddit.
Yes.
Why'd you pick it?
Because I looked on Reddit about scamming, and they were saying if you're gonna make a Telegram, don't ever use your real name.
Right.
Yes.
You testified to your attorney, the reason that you came back to the Eaton Rapids Road address was to get your clothes, correct?
Yes.
And you came back a second time after going to a store and, you know, it's COVID, and that's why you're wearing a mask, right?
Yes, I came right back.
Okay. Were there a lot of other people here in this video?
I'm not sure you have to play it.
Hey, you got it. Let's play it.
No, I don't see anybody.
How about here, People's 54? You came back, right? Wearing a mask? Is that correct?
Yes.
Do you see a lot of people here?
So is it playing or is it a picture?
It's playing.
No, I don't see anybody.
Right, I get why you're confused because there's no one in these frames. That's you, right?
Yes.
That's you knocking the camera over, right?
Yes, that's what I testified to.
Right. I'm so glad you brought that up. You testified with your attorney that you came back, knocked on the door again, and when Alyssa didn't respond, you knocked over the camera. That was your testimony this morning, correct?
Yes, because we used the back, I was using the back door because I parked at this side of the parking lot. So when I came around, I already had knocked on the back door.
Hey, do you knock on this door?
No, this is the front door.
No. And you want us to believe that you're being honest before, that you weren't trying to break in at that point. You were just, you're just trying to see if she would let you come in, right?
No, I just wanted.
Yes or no, sir?
No, sir.
Because you wouldn't try and break in through the window or anything, right?
Correct.
Right. Because all those texts from before, you saying that those were lies, right?
Yes.
Just like this was caused by a baseball bat, right?
Yes.
And I noticed you said today, you know for a fact, for a certainty, this was caused by the baseball bat from the other woman at that tussle at Max Bar, right?
We left together and she had that.
Yes or no? You testified today that you know with a certainty that's what caused that, right?
Yes.
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 Hey, on Tuesday, didn't you say you couldn't actually say if that was it because you didn't see it happen? You just assumed it did?
She told me it happened.
Sir, yes or no? Was your testimony on Tuesday that you didn't know if that's what caused it because you didn't see it? You just assumed that's what it did. Yes or no? Was that your testimony?
Yes.
Okay. What changed between Tuesday and today?
Nothing.
Nothing. So why'd your testimony change?
I mean, I believe her. I have no reason to not believe her.
So you have no reason for why. On Tuesday, you said you didn't know if this is what caused it. You didn't see it. But today, after having a day off, you know with a certainty you're not responsible for that. The woman at Max Bar is.
I'm definitely not responsible for that. Correct.
Right. Just like you're not responsible for the cuts to her wrist, right?
Yes, for sure.
Because the dog did it, right?
She sent me a text saying that. Yes.
Right.
I'm assuming you've seen it because you had her phone.
Sir, only answer questions that are asked of you. Did the dog incident happen at the same time the bar incident did?
No.
No. How far apart were they?
It was a minute. This one, the bar incident was when we were together. I'm not sure. I don't know.
And so the dog incident when you guys worked together, right?
Correct.
So are we talking months?
I don't know.
Don't know.
Whose dog was it, sir?
Her friend's brother's dog.
Who's that?
I don't know her brother's name, but it was the friend Minnie, her best friend.
You didn't cause those marks on her arm, right?
I could have, yes.
You could.
Yes.
How about those?
Yeah, they look like hand marks.
Even that there? That still you think is just from a hand, right?
Scratch, yes.
But this one wasn't you.
No, definitely not.
And this happened when you guys weren't together anymore, right?
Yes.
Got it. So how come these photos are taken at the same time, in the same place, on the same mattress, while she's wearing the same pants?
Objection, Your Honor, speculation.
It's not.
Well,
It's
he's allowed to
observation.
answer. I'm gonna overrule that. Sir, can you answer the question?
Yes, we didn't sleep with sheets on the bed, so that was not taken the same way.
So the fact that she's wearing the same shiny black pants in every one of these photos, the jury shouldn't take away from this that these photos were taken at the same time, right?
Yes, correct.
Okay, so the jury shouldn't take from this that these were all injuries she had at the same moment in time, right?
Can you go back to the wrist?
Yeah, you got it. Yes or no, should the jury believe that these injuries were on her body at the same moment in time?
Objection to the counsel's phrasing of that particular question as to what this jury should believe. He can simply ask the witness what he knows.
Sustained, rephrase.
Absolutely. Your testimony is that despite these appearing to be from the same time, that injury happened when you guys were no longer together, and these injuries that you seem to have caused her weren't close in time, right?
Correct.
Got it. You also want this jury to believe that you did not choke her, right?
Yes.
Because if you had choked her, she would have called the cops, you would have went to jail, right?
Correct.
And you don't remember going to jail for choking her in 2021, right?
Correct.
So if officers were to testify that you were arrested and charged for it, they'd be lying, right?
Yeah, I don't recall.
Great. So if I were to pull up court records showing that you were charged with it, a complaint with your name on it, the date of January 24th, 2019, and the charge of assault by strangulation or great bodily harm and domestic violence for Alyssa Clark, that would be fabricated as well, right?
Are you talking about 21 or 19? Because you just said 2 years.
My apologies. January 24th, 2019. You said.
I was arrested for domestic violence I thought you said.
And strangulation, right?
One at a time.
I don't know.
You don't know. You busted her ribs in May of 2020, right?
No.
No. You broke into her home like you promised to do in the text messages on May 25th, 2020, right?
Absolutely not.
You definitely didn't choke her out that day, right?
Correct.
You definitely didn't hit her again in the ribs, right?
No.
You definitely didn't grab her nursing scissors and try and slash her wrists with it, right?
Definitely not.
Definitely not. You definitely didn't choke her out again in June, right?
Correct.
You definitely didn't, from June and November 2020, stuff a gun in her mouth and threaten to kill her, right?
Never possessed a gun with her. No.
Never because it's the gun.
Never possessed a gun while I was with her.
Just like you didn't possess any when Detective Brandon was interviewing you, right? Because you told her.
I don't know what I told her.
Right. You could have lied to the police. I forgot that. You definitely didn't rape her while she was asleep, right?
100% no.
100% no. You definitely didn't tell Detective Brandon that there was a video of you two having sex and you deleted it, right?
It's the video of her giving me head. I probably was referring to. That's the only one I have on my phone. So that's the only one I could refer to.
So that's the one that you say is deleted.
It had to be. That's the only one that was on my phone.
So the only video that you have taken of her having sex is the blowjob video. That's what you're saying.
Yes.
That's what you're saying. And that's why we know that the other ones have to be photographs, not screenshots, right? Because otherwise they'd have the little bar at the bottom.
Yeah, she alluded that they were.
Great. Thank you, sir, for answering my question. You definitely didn't, while she was unconscious, force yourself in, right?
Never.
You definitely didn't put a sex toy in this, right?
I never.
Yes or no?
Never used a sex toy.
Yes or no?
Sir, you need to answer yes or no.
Okay. No, absolutely not.
Absolutely not. You definitely didn't post her social security card onto Facebook for the world to see saying, I'm willing to sell it for $100 because you wanted to sell it, right?
Correct.
Right, because no one hit your inbox up, right? That was your answer earlier. That shows you weren't trying to sell it because no one hit up your inbox.
No, I wasn't gonna sell it at all.
Right, of course not, because you're not engaged in that behavior, correct?
With selling my baby mamas, no.
Oh, I'm sorry. So you're okay selling other people's information, just not your baby mamas, right?
Not selling other people's information.
Can you say that again?
I'm not selling other people's information. I'm sorry about that.
You're not engaged in that type of behavior, right?
I don't recall.
Of course not. And you want this jury to believe you that you know for a fact you didn't commit these crimes, right?
I never.
Yes or no?
What'd you say?
You want them to believe you as you sit here on this stand and say, I don't remember anything, but I know I didn't commit these crimes I'm charged with, right?
That's not what I'm saying.
I don't think there's anything that could possibly be gained by me asking this man more questions. I have nothing further.
Thank you. Redirect?
Yes, Your Honor, and I'd like to put an objection on the record. We're all familiar with Mr. Pfeiffer's zealous advocacy, but those comments he adds after the witnesses answered, I object to them.
Counsel, you do need to be careful and to not add those comments. They shouldn't be in the record. Thank you.
Absolutely, Your Honor.
You may proceed.
Brooks was, I think counsel referred to something called a fraud box.
Yes.
Did you understand what he was referring to?
Yes.
Okay. And on his insistence, you were answering most of his questions yes or no. Is that fair?
Yes.
Was there something else about that fraud box that you thought was important?
Yes.
What was that, sir?
That's just what got me into being entertained and wondering about fraud. So that was a big part. Yeah.
I heard you.
Okay.
I didn't understand you.
I'm sorry about that. Yes, it's a big part because when I found that box, that's what got me interested in fraud. So that's when I started like Googling, looking into it.
Did you profit at all from anything having to do with that box?
Absolutely not.
Did you return any of those IDs?
No.
Did you turn them over to law enforcement?
No, they haven't. No,
I understand that, but when you
No.
found them, you didn't think to turn them over.
no, no.
Thank you. You may proceed.
Thank you. The let me put it this way. If you found those items in the box at the new place that you had moved into, what caused you to then actually download an app and do additional investigation or exploration with respect to that endeavor?
I don't have a real answer for that other than the fact that I was curious about learning about the fraud because there was so many IDs and social security numbers in there.
The court asked you a question about, did you contact law enforcement? I'm going to go out on a limb and suggest that that was for the purposes of turning that material over to them and perhaps they could get it back to the owners. Did you not contact law enforcement for any other reason?
Correct.
Why else did you not?
Honestly, there's no other reason besides just being curious about looking into fraud.
Right. I'll ask you directly. Were you concerned about being accused of something if you had turned over those items to the law enforcement?
Yes.
On the other hand, you didn't destroy anything that was in the box, did you?
No, I did not.
The security camera footage we have looked at a couple times now, it's in black and white, is it not?
Yes, it is.
And then you indicated that, in fact, that's you that we're looking at, correct?
Correct, yes,
And that's the residence over 2700 Eaton Rapids Road, yes?
yes.
Thank you. Whether it was at that time or another time, earlier in the day or some other time, did you enter that residence on that date?
No, I did not.
Is it your testimony that she was home or not home at that time?
She was on.
And you know that how?
Her car was there and the room light was on.
Okay. You've answered a great number of questions Tuesday and today from both attorneys. Are you satisfied that the answers that you've given have sufficiently told the jury everything you'd like to know, them to know about this case?
Yes, as far as what I was asked, yes.
Right. I'm going to insist on limitations, but what else would you like the jury to know that doesn't have anything to do with any of the questions you've been asked so far?
I would like them to know that even though I'm in these clothes, I still go to jail. When I leave from here, I come from jail. I've been incarcerated the last 18 months. I lost everything. I lost my house, my car, my job. My father passed away. I was hospitalized for 10 days, found out I had Crohn's disease.
And at this point, I'm going to object as none of that should have been presented to a jury at all, but he chose to do it. None of this is relevant here to what we're here for today.
Response?
I did not know what his answer would be. I agree that the court will instruct the jury there not to use empathy, sympathy, pity, something like that in deciding.
Sympathy, empathy, whether he's incarcerated or not, all of the things that he's mentioned, while they may be interesting, they do not go to prove or disprove any element, and sympathy or empathy is not an element of any of the crimes he's charged with.
Yes, Your Honor. Thank you very much.
Thank you.
That was my last question.
Thank you.
I would ask that it be stricken.
So struck. May this witness step down. Oh, I'm sorry. Does the jury have any questions? Number 7. All right, counsel, let's go back and discuss this briefly. You may all be seated. We'll be back in just one moment. No,
Okay. Judge has finished, not us.
I did it. All right, we've returned. Thanks for those few moments. All right, sir, a couple more questions for you. You have personal knowledge, and by personal knowledge, I mean something that you actually know, not that you were told, not that you guessed, you like saw it with your own eyes. Your personal knowledge, okay? Do you have personal knowledge that Ms. Clark is making these claims because of your relationship with me?
My personal knowledge would just be yes. I would say yes.
Oh, how do you know this?
The acts she did afterwards, I think she did.
Which specific acts leads you to that conclusion?
Trying to sleep with my father and close friends. And trying to put me in jail.
Okay. Do you have personal knowledge of how or when Alyssa became aware of your relationship with me?
No, I don't know. It was probably 20.
I don't want you to guess.
Yeah, like, I don't know.
Did she walk in the room when you were having sex? Did she see you two in a restaurant? Was there some event that happened that you recall or no?
Yes, her friend told her.
How do you know that?
I was with her when she sent the text.
So you saw a text that was sent to her that told her about the relationship?
Yes, she showed me.
Does the jury have any additional questions? Thank you. On behalf of the people, any follow-up?
These are once again things you are speculating about that you didn't actually see. You didn't see her receive the text. You didn't see her try and sleep with your father, right?
No, I seen the text. I was with her.
That she received it.
Yes, I was with her.
You were with her when she received the text.
Yes,
And you were with the person who sent the text.
I wasn't with the person who sent the text.
Oh, so now you weren't with the person sent the text, you were with Alyssa when she received it. That's what you're claiming now.
That's the only thing I claim.
Right. And for all of the other things you just said, it's just you speculating, right?
No, she sent it to me.
He's never gonna answer. I have nothing else.
Well, I think that's his answer. Counsel, anything further?
No questions, thank you.
All right, any further questions of the jury? No, sir, I can't have you just blurt out, you have to answer questions. Okay? May this witness step down?
You may, Your Honor. Well,
No objection.
Thank you. On behalf of defendant, any additional witnesses?
Thank you for asking, Your Honor. No, the defense rests.
On behalf of the people, rebuttal.
the people called Detective Sarah Brandon.
Thank you. You may proceed.
Thank you.
And let's keep this to new information. She's already testified quite a bit, so let's,
Yes, Your Honor.
Thank you.
Detective, during the lunch break, you created 2 demonstrative exhibits that are listed as people 70 and 71. Is that correct?
Correct.
What are these?
One is a video I took with my stage to the iPhone. And another is a screenshot from that video.
Do they appear to accurately reflect what you took?
Yes.
People seek to admit and publish people's proposed 70 and 71.
Any objection or voir dire?
Neither, Your Honor, thank you.
Admitted?
And people 70. All right, so that was people 70. That wasn't to capture anything, it was just simply to make a video, correct?
Correct.
Did you then take a screenshot of that video on your phone?
I did.
People 71. Is this that screenshot?
It is.
Does this, anywhere on it, have a bar at the bottom showing the video?
No.
Does it have a play button in the middle of it?
No.
And this is the screenshot that you took of that video we just saw.
Yes.
So, detective, are people able to take screenshots of videos on their phones without having any of the things on them that the defendant claimed?
Yes.
Thank you. Now, you performed an interview with the defendant in November of 2024, is that correct?
Correct.
Did he appear to be under the influence?
No.
Would you have performed an interview with a defendant if they were under the influence?
Absolutely not.
Why not?
Because you're not going to get any kind of accurate statement, and it leaves a lot to be argued in court if they're under the influence.
Was there any doubt in your mind that he was, for lack of a better word, sober?
No.
Did you talk to him about where he has been living?
Yes.
And what did he tell you about that?
That he lived on Millstone for 9 years, and prior to that, he lived on Larned, and that he'd been living on Wilson for about 6 months.
What did he say about who he shared those addresses with?
His mother on Larned, his grandmother on Millstone, and by himself on Wilson.
I'm sorry, Your Honor, I didn't understand the last, the third.
Fine.
Witness said.
By himself on Wilson.
Did you hear that, counsel? By himself on Wilson.
Yes, Judge,
Thank
thank you very
you.
much.
Could you bring the mic just a little bit closer to you?
Yes.
Thank you. Did you then inquire further to confirm that information with him?
Yes.
Did he double down?
Yes.
Did he ever at any point mention even living with Alyssa at Millstone?
No.
Did you ask if anybody else lived there?
Yes.
And what did he tell you?
If I'm remembering correctly, a cousin briefly,
But not Alyssa.
not Alyssa, no.
Did he mention if anyone else lived at Wilson?
He said he was the only one that lived at Wilson.
Did you talk to him about a firearm?
Yes.
And let me ask you this. Had the searches already been conducted before your interview?
Yes.
Okay, so you already knew what was there.
Yes.
What happened when you asked him about firearms?
He said that he had not been in possession of any firearms since 2019 when he was arrested for his CCW charge.
Did you ask him about if there would be guns at your location?
Yes.
And what did he end up telling you?
He told me there would not be.
And just so the jury understands, and they may, but so we're clear, CCW means carrying concealed weapon, correct?
Yes,
Thank you.
Did he ever mention living at Eaton Rapids Road at any point?
no,
Did you talk to them about Alyssa?
extensively.
How did he describe his relationship with Alyssa?
Rocky from the beginning, but he didn't really actually want to be with her. They'd only been involved for a month before she got pregnant, and he had no desire to be with her. He wanted to be with the other woman who he had impregnated at the same time.
How did he describe his relationship with Alyssa? How did he view Alyssa?
I don't remember the exact wording he used, but basically back up when he wasn't with his preferred woman.
Did he call her a rebound?
If not that, something to that effect. I don't remember the exact word.
Mr. Pfeiffer?
Yes. Did he describe how frequently he would see Alyssa when they were together?
He said a few times a month.
A few times a month. So not living there every day.
No,
Did you ask him about GPS on the victim's car?
yes.
And what did he end up saying?
He said he had no idea what I was talking about.
Did you ask him if he had ever messaged her about that?
Yes,
And what did he say?
no,
Did he talk about having a relationship with Minnie James?
yes.
And what did he say when that relationship started?
He said it started in the spring of 2023.
And did he say that's when he was sleeping with her?
He said a few different things. That was one of them.
Did he say if he was still in a relationship with someone at the time of your interview?
Yes,
And what did he say?
that it was Minnie and they had a child on the way.
Did you ask him when he last talked with Alyssa
Yes,
or contacted Alyssa?
yes.
And what did he end up telling you?
I believe it was the end of 2022 was the last time he claimed to have had any kind of contact with her.
Was the last time what?
He had any kind of contact with her.
And did that end up being true?
No,
How about the claim that he didn't have any guns anywhere? Did that end up being true?
no,
Did you find videos of him with firearms?
yes,
How many? Ballpark.
hundreds. There were thousands and thousands of files on the iCloud.
Did these photos or videos appear to be in a recording studio?
Some of them,
How about the ones that weren't? Where would he be when you saw him with these firearms?
some of them I recognized as the bedroom in Millstone, because I was there doing the search, so I went into the bedroom. Various kitchens. Lots of places. There, like I said, there were hundreds if not thousands.
In vehicles?
Vehicles, yeah.
At some point, do you ask him about videos of him and Alyssa?
Yes.
And what does he end up telling you?
He told me that only one video existed of them having any kind of sexual contact, that she knew it was being recorded, and that it was about 10 minutes long. And he had since deleted it out of respect for his new relationship.
Now, you've already testified about the iCloud and how you're not able to see if things are deleted, right?
Correct.
Were there still lots of other videos of him having sex with other women on there,
Countless.
including with the use of firearms?
More than one.
Did you also talk to him about the post that happened
Yes.
with pictures of Alyssa?
Yes.
What did he tell you about those photos that he posted
He said they were screenshots from the video that he had deleted.
of him and Alyssa?
Yes.
Did he tell you that Alyssa was actually awake when he took that video?
Yes. Because he was referring to the oral sex video.
Because he said that those photos that he posted were from that same video.
Yes.
When you reviewed the photos in the video, did they appear to be from that video?
No.
Did you ask him about if he posted the victim's social security card?
Yes.
And what did he tell you?
But he did not.
Did you later confirm that he had indeed posted it?
Yes.
Now you saw in his iCloud Telegram chats that he was in, correct?
Yes.
Under the name Scam Man.
Yes.
Now, you heard him testify that he was on there just because he found this box of people's IDs and, social security cards, credit cards, and it just got him interested in scams and identity theft, right?
Yes,
Just as an entertainment thing is how we refer to it towards the end there, correct?
yes,
From your view of his actions in those Telegram chats, did it appear to be for entertainment purposes?
no, there was bartering happening, instructions back and forth about how and where to access different things.
Thank you. Did you talk with Mr. Brooks about Felissa drinking?
Yes,
And what did he tell you?
that she does not drink that often. And he doesn't like to drink with her because she can't hold her liquor.
Is that what he testified to in this trial?
No,
Did his testimony line up with what he told you in November of 2024?
barely at all.
In between his statements to you that there was a video of them having sex, but he just screenshotted it. Actually, let me go back. Did he talk about them actually having sex, his penis inside of her, on the video that he claims he deleted?
Yes, he said they had sex.
So in between him telling you these things, that there's no gun, there's no social security card posted, that he barely ever saw her, that he's never been to Eaton Rapids, she's never lived with him, and testifying this week, two pretty different stories he was telling, right?
Pretty much the opposite.
And in between those two stories he's told, he saw Alyssa testify.
Yes.
I have nothing further.
Cross.
Yes, Judge, thank you. With your help, I'm going to try to take who said what out of the picture and just talk to you about what happened, what you did, okay?
Okay.
Thank you. Law enforcement, whether it was you or somebody else, somebody seized Mr. Brooks' cell phone. Is that a fair statement?
Yes.
And it was taken somewhere to be analyzed in some fashion. Is that also true?
Yes.
Is that something you did or participated in or someone else?
I collected his phone from his property in jail, and then I took it to the computer crime unit at the state police to have it extracted and analyzed.
Did you participate in the actual extraction of data?
No.
Okay, and well, let me ask you this. There was a time when if you dropped something off at the state police crime lab, they fill out a little form and asked, you had to indicate to them what you wanted them to do with it. Does that still happen?
Yes.
Okay, and is that, whether it's a form, is that something that you did?
Yes.
And do you recall today what you asked the crime lab to do with Mr. Brooks' telephone?
I wrote a list of the things he was charged with, and then asked them to find things relevant to the charges that were issued.
If you recall, did you ask specifically to see whether there was a video, the one that was described by Ms. Clark, where she was unconscious and so on and so on?
Yes.
And what was the result of that?
They could not find it.
I'm not asking you as an expert. Is it your understanding that the Michigan State Police Crime Laboratory has the ability, even if as a consumer I hit delete, it's still there?
I think at this point, he is asking her to testify as an expert.
Well, based on your knowledge, and is it working as a police officer, just using your own, do you know?
It's my understanding that it depends, but on what, I have no idea.
Thank you.
Thank you. You're confident that in some circumstances it's possible?
Yes.
Thank you again. All right. I heard you talk about videos, sex videos, and firearms. That right away just sounds not good. What what did you see? What are you talking about? Videos with sex and firearms?
I observed a video of him having sex with a woman from behind, and he produces a firearm and points it at the back of her head. And when she goes to adjust, he pulls it back pretty aggressively, in my opinion.
Pulls what back?
The firearm.
From where?
He had it extended out in front of him, pointing it at the woman. I don't believe it to be the victim.
You,
There was more than one, if you want me to talk about the other one.
well, right now, from what you could observe, I know you weren't there, from what you could observe, did it appear as though the female half of that sexual interlude was able to see the firearm?
No.
Okay. And I think you and I crossed this bridge the other day. It's difficult to be 100% sure as to whether any firearm you see in a video is the same one that came in that box earlier.
I suppose definitively no.
Okay. It might look like it, might be the same size, might be the same caliber, might be everything else the same, but you can't say for sure.
Correct.
Thank you very much. Do you have a memory today as to how many videos there were involving Mr. Brooks and Ms. Clark?
Not specifically.
Okay. And one of the last things I think you answered to counsel's question was whether Mr. Brooks told you during his interview that he and Ms. Clark engaged in some type of a sex act on the same day that the photos were taken of her with her eyes closed and so forth.
Yes.
Did he tell you that it was while she was blacked out or unconscious, or was it a couple hours later?
All he said was that she was awake.
Okay. Thank you. And I'm going to go sit down, but as I do, I just would like to ask this, if you know, this examination by the folks over at the crime lab, did you, as the investigating officer, receive some kind of a report?
Yes.
And in that report, did it list all of the various photographs and videos and so forth, or
Some
no?
of them.
Okay. And was the same thing done with Miss Clark's telephone?
No.
Okay. Is it fair for me to ask and for you to answer that whether it's text messages, photographs, anything from her phone, she presented, that you did not have her phone inspected and make selections of certain things? She offered those things that we've seen.
She sent me screenshots. Typically, I try not to confiscate victims' phones because we have to dump the entire thing. They're already traumatized enough going through this entire process, so I try not to do that if I can avoid it. And when I did dump his phone, I got plenty. A lot of the text messages and screenshots she sent were also in his iCloud, so I didn't find it necessary to also get her phone. Had I got nothing, I would have, but I'm gonna go offender first.
Okay, you answered the question that I didn't ask. That was why. But the only thing I want everybody to understand is that you made the decision, or law enforcement made the decision, as to which parts of Mr. Brooks' phone would be relevant in this particular case.
Yes, I made that decision.
Thank you. And it was Ms. Clark who made the decision as to what she thought would be relevant from her phone in this case.
Yes.
That's all I have, Your Honor. Thank you.
Redirect.
When a phone or iCloud is turned over to Michigan State Police, you do list certain things you're looking for, correct?
Yes.
Do they still dump the entire phone?
They have to. There's no way to do partial phones.
So the entire phone is still turned over and presented?
Yes.
It's not the Michigan State Police cherry picks what to provide out of the phone, correct?
Correct.
I have nothing further.
Wait a minute, does the jury have any questions? Seeing no hands raised, may this witness step down.
She may, Your Honor.
Without objection.
Thank you. Any additional rebuttal witnesses?
None, Your Honor.
People close?
People do.
At this time, we are going to have closings. Do you need a moment?
15 minutes. A lot developed this afternoon, but I don't need a terribly long amount of time.
Would you like a few minutes before we go to closing?
I would, Your
All
Honor,
right,
and
let's
then with
take-
those, I'm sorry. Yeah, I would like the three of us to visit.
All right, thank you. See you in 15.
No, we have the preliminary matters we need to address on the
Oh,
record.
that's right. Okay.
I'm grabbing the update your instructions in a moment here.
Thank you. We are back on the record, and at this time, we're not going to bring in the jurors because I understand that there have been a few changes with the proposed jury instructions. Is that correct?
That's correct, Your Honor.
Okay.
There are changes that have been agreed to, and then there are some that the defense is requesting, people are opposing. Figure we just start with the ones that we've all agreed to.
All right.
The people are modifying the date range for counts 9 and 10, the felonious assault and the accompanying felony firearm.
And that's been stipulated too. Is that correct?
That is correct, Your Honor.
Okay, thank you.
It now reads between June 2026, June 2020 and November 2020. I certainly hope that's what I put there.
wrong already?
Hold
What?
on, I put in the.
I'm sorry, what page is that? Or what charge is it?
9 and 10.
Okay, 9, we have June 2020 and November 2020, correct?
Great, I just misspelled it in my email. We're good.
Okay, I've got it right in front of me. And it has page numbers, so.
I drank 2 Red Bulls, a coffee, and I got electrocuted. Don't give me this heart attack.
We can use a bit more. We are adding in 20.27, that being the consent instruction, because while the defendant is still, and the defense is still that the sex act did not occur for count 13, the criminal sexual conduct in the first degree, technically, there is evidence on the record that he told Detective Brandman that the sexual act that was in the video was consensual. And therefore, for appellate purposes, I believe that it is required to be in the jury instructions.
All right, so that is page 29, it's 20.27 consent, that is in the instructions.
And then the people are also changing the theory of the criminal sexual conduct in the first degree. Instead of obvious, it's being changed into PIM, because again, that is what he said to Detective Brandman on the video. And while I could technically add a completely separate count of criminal sexual conduct in the first degree for that, I think it's just significantly simpler and easier to modify the theory of count 13.
Okay, thank you.
Without objection on that issue, Your Honor, thank you.
Thank you. Okay, next.
That is all that we have. Oh, and then there was one that was erroneously in there about behavioral expert that was caught and removed.
What did you just say?
There was an erroneous instruction in there about behavioral expert testimony that
Oh,
was from a previous trial.
okay,
It was caught and it was removed.
all right, thank you.
Thanks very much, Your Honor. I have a couple of concerns I'd like to express. The first is with respect to the count of home invasion in the first degree. My reading of the statute, as well as my reading of the instructions, counsel is going forward on what I'm going to call 2 separate theories. That is to say, whether the defendant broke and entered the residence or whether he entered without permission. I'm of the opinion that the jury should be instructed that if they find guilt beyond a reasonable doubt, it must be by one of the 2 theories rather than splitting, some saying it was breaking and entering and others saying it was unlawful entry. I believe they have to be unanimous as to which of those 2. This second issue is with respect to criminal sexual conduct in the first degree. I want the record to reflect that I have considered the lesser included offense of the third degree, but I'm not asking for it. And the reason is because it has been my client's position that there wasn't any.
Okay,
And so I don't think it would stand muster to the Court of Appeals if it was appealed for that reason. I also would like this record to reflect, and for the overworked and underpaid attorneys and clerks at the Court of Appeals,
that yes, there were search warrants involved in this case, and yes, I think an argument could be made that they were general warrants. But I'm also aware of I think it's a 2025 opinion by the Michigan Court of Appeals that states that as long as the law enforcement or the crime lab follow the protocol, everything from placing the device in airplane mode to the extraction of the data, if they have preserved an exact copy, then they can ask for a second search warrant and go back. And so I intentionally did not challenge them because I'm aware of that other case. And so I just wanted to indicate that on the record.
Thank you.
The last concern I have, Your Honor, is the wording of our instruction 3.20. The most significant challenge I'm placing on the record is the very last sentence. It currently says, you may find the defendant guilty of all or any combination of these crimes or not guilty. Number one, I think that's confusing. And
Sir, what page are you on?
I'm on page of the new, I'm looking at what is 54 of 100, but I think it's a different page now. It's instruction 3.20.
I'm just looking for it.
Single defendant, multiple counts, more than one wrongful act.
Okay,
Page 50.
I got it, page 56, yes.
Okay. The very last sentence, I think, is at least confusing, and I think it's prejudicial against any defendant, including my client. You may find the defendant guilty of all or any combination of these
Well,
crimes.
you know, I want to interrupt you there because I have often thought that. I appreciate you mentioning that. How about we change it to you may find the defendant guilty of all, none, or any combination of these crimes, or
Thank you.
not guilty.
Thank you, Your Honor. Consistent
Because-
with the verdict form where traditionally we list not guilty first, I'm respectfully suggesting you may find the defendant not guilty or guilty of all or any combination of these crimes.
The people have no objection to that.
All right, so I'll change it to you may find defendant.
Not guilty or
not-
guilty
Yeah, not guilty or guilty
of all or any combination.
of all, none, or any combination of these crimes.
The people have no problem with that, Your Honor.
Yeah, I appreciate you mentioning that, because every time I read it, I think that's weird.
No,
But
that's-
that's the Supreme Court problem, so we'll change it, maybe they'll get the message. Thank you for raising that.
Thank you, Your Honor. It was the penalty one that always disturbed me, but that was corrected. So now
Have you all agreed on the verdict form? It looks appropriate?
I believe so. Yes,
Okay. Okay. Anything else?
but I'm still.
So we are at 3:45. We can do closings and I can read these in the morning, or I can do all this. I suspect by the time you get both done with closings, I'm not gonna have time to read this and then they're gonna deliberate.
I'm happy to do whatever we're able to do today.
Then let's get to closings and see how much time we have. It may very well be that tomorrow morning I open up with this and then they deliberate.
Absolutely.
Because this is, I don't know, how long did it take me to read the first set?
Good
Probably
chunk.
40 minutes, 45 minutes?
think so.
Let's see how well we do. It might be fresh to give them these, first thing in the morning.
I'm happy to do the most with the time we have.
All right, then maybe bring in the jurors.
Yes, Your Honor.
Your Honor, just to make sure I'm clear, this court is wanting to, or is not wanting to have the council give our closings and then immediately give.
I want you to give your closings and then I'm gonna see how much time is left. And then I will either read these and send them back, or we'll just end then and go in the morning and we'll read this in the morning.
I understand. Thank you.
Okay, thank you. The jury queue, you may be seated. On behalf of the people, closing at this time.
Yes, Your Honor.
You may proceed when you're ready.
Okay, that's good. Good afternoon. I told you at the beginning of all this was not going to be an easy trial to sit through, and I'd like to think that I kept true to my word. But that doesn't mean that the decision here is different. What you heard in this trial was Alyssa tell you in pretty pretty specific detail what that man did. That was corroborated by the text messages, by his messages to other people trying to get someone else to go beat her up, by the surveillance videos and the medical report showing she went to the hospital on January 24th, 2019, because she had just been a victim of domestic violence. Things that I didn't even know existed. She was more on top of this than even I was. She did not falter when questioned about specific details from different events. She said, I don't remember when this one happened, but this is what happened. She told you in detail about what she saw in that video, which is then bolstered not only by what was found on the defendant's iCloud, but by what the defendant told Detective Brandon. There was a video, and he deleted it out of concern and respect for his new girlfriend. Didn't delete any of the other ones. Didn't delete the ones where he's shoving a gun inside a woman or pointing on the back of her head. Because that definitely wouldn't offend his new girlfriend, but that one would. So he deleted it. Is that reasonable? Is it reasonable to believe that he was high that day, the detective had no idea, and that means he doesn't remember a single thing that he said to her? No. Is it reasonable to believe what he told you? You have to figure out which version of what he told you, because that shifted. Was it reasonable to believe that Alyssa, as I testified about this multiple times, spoken to multiple officers, and is making all of this up, is fabricating text messages, is fabricating evidence because he slept with her friend 5 years ago now? There is no reasonable doubt here that that man abused her, beat her, and violated her. There's no reasonable doubt because you could have been able to see with your own eyes how he would treat her. You are my property. I own you. The only way out is death. I'm coming for you. I have a GPS tracker on your car. I know where you are. I'm coming for you right now. Get ready. I'm going to kill you, you bitch. I love you so much. Come on, let's just do that. I'm going to kill you. I swear it on my children. I swear it on the Bible. I'm going to kill you. I don't think he wanted to kill her. I don't think he meant to kill her. I don't think he intended to end her life. I think he wanted to make her believe that. I think he wanted to scare her down to her last fiber of her being, that he could kill her at any time. I think he wanted to have someone to abuse, to have power and control over in any way he saw fit in that moment. You heard from Alyssa. You heard from officers who searched this place, who found firearms, like in telling Detective Brandon, nope, haven't touched any guns since 2018. Oh, and yes, there's lots of videos of me with firearms, but no, those were just props. Those are just props in music videos. Except you heard testimony, the firearms they found at the 2 locations weren't props, they were real guns, including the one at Millstone. It was broken, but it was real. This wasn't some BB gun, this wasn't some plastic prop. This was a firearm. You could see the parts of it that were broken that were sitting next to the gun in the case. That's not a prop. and then the firearm that he was hiding under his bed. Don't worry though, that was definitely for safety purposes. Not going to use the gun box with a lock the other place that I can replace with any lock on this earth. I could just go down and drop $3 on one. Nope. Because, you know, key jam. What could I? Also not going to put it up on the high counter. They talked about looking around when the magical box of fraud documents drop down. No. In the bed. Closer to the ground and the height of children. In the bed. How could I possibly have known that the gun was stolen? Yes, I bought it off a man who I refuse to name. I don't think anybody missed that. Who'd you buy it from? I'm not telling. You have to. I don't recall. Is that not the entirety of the defendant's testimony in a clear 10-second nutshell? I don't want to answer this question. I don't want to tell you what happened, so I don't recall. By the way, went back and checked. When I asked how many times do you think you said I don't recall, it was 55. And that was only about halfway through. He can absolutely recall the parts he wanted to. It's not about memory. It's about what do I think is going to help me the best right here, right now. What's going to help me the best when being interviewed by a detective about crimes against Alyssa Clark? I barely know her. We've got kids together, but it's not serious. No, I've never lived with her. What? No, I only see her like 3 or 4 times a month. That's it. And that's when we're in good. So, no. And then what do you think is going to help him here? Look, we were together. I was living there, but she's crazy. There's a reason that they don't line up. One set of statements was made before he knew what the evidence against him was. Before he'd seen Alyssa testify twice now. While he refused to admit it, you all heard his testimony on Tuesday. The first I ever heard of a video showing me raping her unconscious body was a week before trial when I was revealing discovery. He refused to acknowledge that that's what he said here. Steadfastly denying. You all heard him. The first I heard about this rape video was a week before trial. That's not true. As was brought out through my cross-examination, when he would answer my questions, he was at the preliminary examination back in 2024, December of 2024, with the lower court where Alyssa testified, and he heard her testify about this video that she found of him violating her. Well, that doesn't help him in this moment, so now it's no, I never said that on Tuesday. None of it lines up. Even with just himself, it doesn't line up with his own statements. He tells Detective Bramman, no, I deleted the video. Those things were screenshots of the video, and I deleted it. But it was definitely consensual. We had sex. I had my penis inside of her, but no, I got rid of it out of respect for my new girlfriend. They can't be screenshots because any screenshot has the video showing at the bottom of it or a play button in the middle. He testified about that, I think, 4 or 5 different times. And it took a single 30-second video and a screenshot that was made during the lunch break to prove that wrong. No. I never posted her social security card online. And then when it's confronted with it in front of him, okay, yeah, I did, but I wasn't trying to sell it. He was asked, why does this post not indicate you're selling it? And his response was, because no one hit up my inbox. There was a pause as everyone realized how damning that statement was. And he then followed up with, and I wasn't trying to anyways. He would never do that, except for all the Telegram chats, which again, he has no idea why he posted the video of the box of fraud in there, and he will not look at it to see why. Do you want to look at the chats about what you were saying around when you posted that? Nope. Did you send these text messages? Nope, those are fake. Well, no, but those ones are real. Those ones are real there. How about the ones immediately after those? Nope, those are fake too. Part of your job as jurors is judging credibility. As I've already said at the beginning of this trial, what I tell you the law is, that doesn't matter. It's what the judge tells you the law is. But I have a sneak peek of what that is. Both attorneys do, because we have the instructions that are going to be read to you. So I'm going to give you a sneak peek. Witnesses, credibility. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Did the defendant seem to be making an honest effort to tell the truth, or did he seem to evade the questions or argue with the lawyers? I don't need to belabor this point. It was clear he did not want to answer my questions. He didn't even want to tell me what month October is. There are 18 counts charged here. Not all the crimes that we heard about today. Sorry, this week. Not by a long shot. But this is what we're here for today. I'm going to go through these as best a timeline as I can. May 2020, count 5, assault with intent to great bodily harm, less than murder. Leading up to the May 25th incident where he is bashing her in the ribs to the point that they break. And where she is so worried about losing custody of her children that she doesn't go to medical care. So let's be clear. He has been assaulting her since 2018. That's when CPS started, because of that. Why would it make the CPS issues easier if he was not around her? Because he was hurting her. An acknowledgement that she is gone back to the man who has been beating her puts custody of her children at risk. And she valued that more than her health and her safety and her pain and her suffering. Right or wrong, her priority is that she can have her children in her life. She does what she can for the pain. Wraps it up, takes an Advil. And only a couple of weeks later, May 25th, 2020, he breaks in her door. How do we know by breaking? He opens it, it's unlocked, and forces his way inside at great speed. How do we know? Well, it testified to it. And it also helped that he was texting her that day, I'm gonna come bust that door down. It helps that he was saying, on May 8th, in the exhibits that have been admitted, I'm coming over there, I'm gonna break that door down. I'm getting inside. And while he's tried to say, no, I lived there. I didn't break in, didn't need to break in, didn't need to force my way inside, didn't need to enter without permission because I lived there. I could come and go as I pleased. I'd drive to work, I'd come back, play video games. I had free reign. But what happened on the cross? Because he was very loosey-goosey with the times until it was nailed down. His claim, not the truth, his claim is that he left there around October of 2021. He was there for 6 months. Means he moved in by his own version of events, April 2021. So he was not living there on May 25th, 2020 by his own story. In fact, he ended up saying, well, I don't know. I just have no way to know, which means he has no idea by his own second version of events if he actually was allowed to be there that day. Only there was some way that we could know which of these stories is true. Wait, we have the text where he says I'm going to break the door down. We have the text afterwards of her saying, the police got called because someone saw me running out of the house bloody. While he was there, he strangled her, he beat her, kept punching her again in the same ribs. He saw her nursing scissors on the dresser. He grabbed them and he tried to slice her wrists. She had to fight him off to stop it. Now, once this had started, she said, I am going to call the police. I want to call the police. And he made sure that she couldn't. He made sure that the phone he ripped out of her hands, she could not gain access to, which is why she had to flee just to call for help. June 2020. As she said, sometime in June, where he was beating her again and strangling her unconscious again. And then, in a time period somewhere between June and November, he took one of his handguns and put it in her mouth and threatened to kill her. Now, the defendant also wants to try and claim, well, no, that's a prop. Pretty sure when you have a steel barrel in your mouth, you know that's a gun. He strangled her again over the course of 2020. Put his hands on her. She did not want it. And he would frequently choke her either unconscious or almost to the point of unconsciousness. And then we have the CSC in the first degree, criminal sexual conduct. Some point in 2020, to be clear, the people do not need to prove when that crime happened, just that it did. But the best she was able to narrow it down to in her memory was 2020. She had a couple of shots with him, blacked out, which, as she said, is not something that happens to her. That had never happened to her before, not just from that level of alcohol, but period. And she was woken up later by him putting her in the shower. Water just careening down on top. It wasn't until looking through his phone weeks later that she saw the video. The video of herself naked and unconscious, of him moving her and throwing her around, flopping to and fro, of him putting his penis in and having sex with her when she could not consent to it, and then, for good measure, taking a sex toy and putting. That's how she found out she was raped. She had to watch it in HD. She told you how this affected her. She told you about how after all this from Enrico Brooks, she ended up being,
after what?
all this from Enrico Brooks, she ended up being diagnosed with post-traumatic stress disorder. How she would have to, you saw in the text, have to cover her arms because her coworkers were starting to notice the bruises. about how traumatic and damaging this was for her. To the point where even having to relive that incident, she ended up having to take time off of work because she was not in a good state. One of the elements for criminal sexual conduct is the first degree is what's called personal injury. That means either physical injury or mental anguish. And the evidence shows she suffered mental anguish. Once again, preview of the instructions are going to be read. Mental anguish means extreme pain, extreme distress, or extreme suffering, either at the time of the event or later as a result of it. Here are some of the things you may think about when deciding whether Alyssa Clark suffered mental anguish. Was she upset, crying, or hysterical during or after the event? Did she need psychological treatment? Did the incident interfere with her ability to work or lead a normal life? Was she afraid that she or someone else would be hurt or killed? Did she feel angry or humiliated? Did she need medication for anxiety, insomnia, or other symptoms? Did the emotional effects of the incident last a long time? Her testimony of what she has had to go through because of this clearly establishes mental anguish beyond any reasonable doubt. Then we have September of 2023, the postings. Computers using to commit a crime, personal identifying information, obtaining, possessing, transfer, or intent to commit identity theft, and intentional dissemination of sexually explicit visual materials. So the first is him posting her social security card to Facebook so someone can buy it, take her identity, and scam her. He wants you to believe this was a fear tactic. It wasn't. All of the evidence here points to the fact that he was trying to fuck up her life. Well, he'd never do that, except we have the Telegram chats that show it. He had put her ID or social security card in the box of other people's IDs. What I colloquially call the fraud box. One that he posted in the Telegram chats where they're committing fraud. The elements for that either did seller transfer or did attempt to. He didn't have to succeed, he just had to try. And he tried. By any amount of reasonable measure, the evidence shows he tried. And then, using computer to commit a crime, he used Facebook to commit that crime. That's done either off a cell phone or a computer. No matter which of those sources it was, doesn't matter. He used a computer to commit the crime of personal identifying information, obtaining, possession, or transferring with intent to commit identity theft. That is from the posting of that on Facebook. And then we get to intentional dissemination of sexually explicit visual materials. I am not saying that the photo of her face or of her stomach that he posted alongside that to Facebook is the sexually explicit visual materials. I'm not. I'm saying that the naked photos and the video of her giving him a blowjob that he posted to Reddit is. And while he wants to claim, no, I didn't, that's not what that means, he never actually had an explanation for why he said that. You're going viral on Reddit. Right after he said, it's up. Meaning it's up there. It's uploaded. It's up on Reddit. He's not shy about using language when it comes to, I'm going to fight you, I'm going to beat you. He showed her what he posted on Reddit, an anonymous website, unlike Facebook, and said, up there now, you're going viral, bitch. That is the intentional dissemination of sexually explicit visual materials. How do we know what happened? Because he taunted her with it. Brings us finally to November 19th, 2024, where he had a stolen gun. It was stolen. He knew it was stolen, or per the law, should have reason to believe it was stolen. He knew what the proper procedure was for buying a firearm. He had done it before. He was then got in trouble for concealing it, but he knew the proper way to go about this. the forms, the registry, the minutia that is involved with this process, the background checks. And then he bought this gun off the street with a person he refused to name that involved none of that. And he hid it in his home. He didn't hide the non-broken one. He hid, sorry, the non-stolen one. He hid the one that was stolen because he knew it was stolen, or he had reason to know it was stolen. The situation was so sketchy, he refused to give a name. He knew what that was. He knew what he was doing, and his actions once he got that gun show that. The last count here with a very wide date range, November 2018 through January 2024. Aggravated stalking. Did he make 2 or more unconsented contacts to Alyssa Clark? I think it's pretty clear from the testimony and the messages that he had to do from other accounts and friends' phones because she had blocked him, shows they were unconsented contacts, including her saying she did not want to talk to him, leave me alone. And then the other element, did it make her feel frightened, intimidated, threatened, or harassed? Absolutely it did. He was threatening to beat her. And finally, the aggravating factor. There's 2 options here. Did these include threats to kill or injure? Clearly they did. We could see them with our own eyes. And in the alternative, was any one of these contacts in violation of a no contact order or a personal protection order, an order from a court saying you're not allowed to talk to her, and your testimony from her that they were, and you can even see the text message. That was from 2024. Baby, I love you so much. Again, while the court case is going on, about September 2023, I love you so much. Give the kids happy birthday for me. You know, we can really sort this out. That message is the entire reason Detective Brandman got involved in this case at all. To confirm dates and times for the contacts and the no contact orders. That is what spurred and resulted in Alyssa sitting down with Detective Brandman, and then what should have been a 30-minute interview turning into 3 hours because of the amount of pain and suffering that man put her through. I am asking you to find him guilty of all of these charges because the evidence shows nothing else. There is no reasonable doubt here. People are conspiring to fabricate evidence against me. That's not a reasonable doubt in this case. He was not a credible witness by any measure of that definition. I'm asking you to find him guilty because the evidence shows nothing else. Your job is to decide what happened based on the facts you have and determine if these crimes were committed based on the law that you're given by the judge. Your job is to be critical, open, and honest with each other in your deliberations. You're required to be unanimous across all of these counts. Sorry, for each count, you're required to be unanimous on the elements. You all agreed the elements for this count were met, each one of them, in order to come back with a verdict of guilty for that crime. There are several crimes here with alternate theories. Just talk about one with the aggravated stalking. Another one being the home invasion. There are 2 theories for home invasion under the law. The first being breaking and entering. It's defined as any amount of force used to enter a building. That includes opening a closed window, opening an unlocked door. That is a breaking under the law, and then entering. Committing assault while in there, there's another person lawfully present. Listen. The alternative theory is entering without permission. Door can be wide open. Don't have permission to step through that door. That is entering without permission. And once inside, made an assault, and Alyssa is lawfully there. That is the home invasion. You do not all need to agree unanimously which one of these theories are met. Half of you can think it was a breaking and entering. Half of you can think it was just entering without permission. But as long as you all agree that one of these theories was met, you're required to come back with a verdict of guilty. That is the law. Now notice there was something that was changed since I have made this in my opening statement. That being these two counts. Count 9 and count 10. Assault with a dangerous weapon and felony firearm. It is not an exaggeration to say that the testimony showed he threatened her with guns numerous times over the course of 2020. But the one that appeared to be the clearest and the most detailed was the pistol inside her jaw, which she said happened between June 2020 and November 2020. So the people have amended the date range to reflect that accordingly. The other one that has been changed is criminal sexual conduct in the first degree. I told you that the theory was the penetrative act that happened was a sex toy interest. And I'm not saying that did not happen, but this has been changed to penis infant. Why? Because he admitted to Detective Brandman that that part of it happened. He still claimed that it was consensual and that she was awake, and that those photos he took, she was awake. The photos where she has her eyes closed and where he is prying her mouth open. She's apparently awake there. Because remember, he told her this is from the video where they had sex that he deleted. But because he admitted to Detective Brandman, people thought it would be most prudent to change the penetrative act for count 13 to reflect that. Because that is not one where I can list both. It would need to be an entirely other count. And I think 18 is enough. There is nothing that can be done to make Alyssa the person she was, or the person she would have been if that man hadn't abused her, threatened her, and beat her, and extorted her. I asked her why she was here. If she knew how terrible testifying was for her the first time around. Why she's here after reporting this back in 2024. Here in 2026. She told you why. So there can be justice for what was done to her. I am asking to find him guilty of all 18 counts because there's no reasonable doubt that he is not guilty of those. I'm asking you to hold me to my burden and to do what you swore you would do. Be honest, be critical, and to use your common sense when you're evaluating the testimony and the evidence in the case. Thank you.
On behalf of defendant, closing.
Yes, Your Honor, thank you.
You may proceed when you're ready.
Thank you. I will need just a half a moment.
That's okay, take your time.
Good afternoon. This trial has not been a particularly lengthy trial as they go, a couple of days. And so because of that, I don't think it's necessary for me to go through each and every witness or each and every count and reiterate things that you've already heard or things you've already seen. I don't think that's necessary. I will touch on a little bit of that, but not extensively. One thing that I'd like to make clear immediately is that during my comments, I may say something about the evidence in the case. So-and-so told you X. If that's your memory, great. If that's not your memory of what that person said, you must go with what you recall, not what I'm recalling, okay? And by no means am I suggesting to any of you that I'm quoting the law that you are to follow. That's the judge's job, and she'll take care of that probably tomorrow. So listen to what she tells you about what the law is that you're supposed to use, not myself and certainly not Mr. Pfeiffer, although we may allude to it from time to time. All right. The first thing I'd like to get taken care of here is, I have to follow my own rules, stay in front of the microphone. What I think is the elephant in the room, and I'm just going to say it out loud. I thought that the entirety of the testimony of this trial
suggested strongly childish behaviors. Oh my gosh, we've got people who are what, early 20s, mid 20s, and acting like children at a playground or at a school. Just, you know, so-and-so did this, and so I did that back. You know, the name calling and all of it. That's my impression. You've got your own. I'm just sharing with you. It seemed like it to me. And I say that for two reasons. Number one, because I think it is the testimony of what did or didn't happen is childlike. We would expect adults to act differently. But I also bring that to your attention because I also think that it's not necessarily true, it's not automatically true, that childish behavior is the same thing as criminal behavior. We're focused on criminal, not lack of maturity or some other side issue. The situation is that my client, Mr. Brooks, has been charged by the prosecuting attorney's office for crimes that are alleged to have taken place over a period of years. Over a period of years. I don't know that the memory of Ms. Clark or my client or of any witness is going to be razor sharp years afterwards. So with all due respect, I'm respectfully asking that, you know, maybe we need to allow for a little bit of variance. Well, it was 2 o'clock in the afternoon. Well, maybe it was 3:30. Okay, but if it was 4 years ago, you see what I'm saying? It doesn't mean lying. Our position is that Ms. Clark, Alyssa Clark, has exaggerated her testimony. She has exaggerated any statement that she gave law enforcement. And in support of that contention, we now know that it was a police detective who looked at the materials located on Mr. Brooks' phone, and it was she who determined which portions of that data were useful in terms of bringing prosecution against my client. Whereas it seems to be undisputed that Ms. Clark's phone was not examined forensically by the crime lab, that it was Ms. Clark who went back in her saved files and hand-selected various text messages, photographs, and what have you, and presented them to law enforcement, who of course passed that on to the prosecuting attorney's office, and they made a decision that 18 serious crimes were committed. And so here we are. I don't think it's a stretch. I don't think it's a stretch that if Ms. Clark had in her phone, you know, she's scrolling through and she's, there's a nasty gram from him right there, and set that aside. And here's something else that he set that aside. Okay, so these are all negative things that I can point to that were either written by Mr. Brooks or photographs taken by Mr. Brooks or whatever it was, and I can select which ones I'm going to turn over to law enforcement. Well, how difficult would it be then to come up with a story to match what you know you're going to give them? I keep coming back to that fantastic bruise on her right thigh. I mean, that is some kind of bruise. And without being a medical professional, any of us, I don't think it's a stretch to look at that and say, wait a minute, that was a direct result of a man's fist. That was a direct result of Mr. Brooks' fist in particular. It didn't come from anything else. There wasn't any other reason why you chose to save that photograph, to take the photograph and to save it. If someone is just a natural collector of things, I'm not talking about hoarding, but you know, if you just, you tend to save text messages or photographs on your phone, that's fine. But to then suggest that I'm going to need to say something that points a finger of criminality at Mr. Brooks, when anyone looks at this photograph, it's going to support my oral representations, okay? And this adage of actions speak louder than words, I think that that's true. I think it's particularly true with respect to Mr. Brooks. Did he make claims of going to do this and I'm going to do that and I'm going to huff and puff and blow your house down? Yes, he did. And they're all in evidence and you can look at them as long as you want. They're all there. All right. And so it's a written word, but it's more verbal. And so what happened as a consequence? Her house burned down? No. She was killed? No. Kids were hurt? No. What happened afterwards? It just is consistent with what Mr. Brooks told you, that the only reason he was on her is because she posted sexually explicit images involving him. Okay? That's what one of the counts that he's charged with. And his attempts to get her to take it down, we don't have to agree with his methodologies, but those were his attempts to get her to take that stuff down, which she should have. And had she taken it down, as soon as she found out, oh boy, he knows about it, he's going to go ballistic, boy, oh boy. Then why didn't she just take it down? Why didn't she just take it down? The longer she left it up, the more upset he got, insisting that she take it down. But he did not physically harm her because of that. He sent these messages, you better, and yeah, they're pretty graphic. And some of them are just, the kind of message that if you got it, would prompt most anyone, I think, to comply, to say, boy, I'm going to take that down, right now. But she didn't. And so the text messages continue. This couple of these, I just have to tell you, I don't understand, but if you, as a group of 12, are able to come up with a verdict, terrific. The first one I'm starting with is this whole idea of torture. It's the very first charge. And you're going to hear the judge tell you tomorrow that in order for you to vote guilty and to convict Mr. Brooks of torturing her, you have to find each element proven to your satisfaction beyond any reasonable doubt. Each and every one of them. If you get to the second or third element and you find that, well, yeah, that I don't think there's sufficient evidence or sufficiently reliable evidence, then you can stop right there and you mark the box that says not guilty, you go to the next one. It's not difficult. Your job is not to solve crimes. Your jobs are not to figure out something. Your job is simply to say, okay, which evidence do we find reliable? I'm reluctant to use the word believable. You do as you choose. But is it reliable? And you heard Ms. Clark testify. If you found all of her testimony reliable, okay. I'm thinking that at least some of you maybe didn't. Not 100% reliable. Not reliable to the extent that you should count on it and say, yep, that's enough for me to, I don't have any doubt, I don't have any reasonable doubt about this particular charge or criminal offense, and because of what she told us, because of what she said happened. It's just like going to the hospital. You know that little form, it said the date that she went into the hospital, and it says the reason she was there. And yes, I saw the word domestic violence just like you did. Well, where'd that come from? Was that Dr. So-and-so after consultation saying, in my professional medical opinion, this is what this person is suffering from? Or no, it's what she told them. In the medical profession, they say, get a history of the patient. What's that mean? It means you go to the patient and you say, well, have you ever had a heart attack? Have you ever had kidney disease? Have you ever, are you on any medications? You get a history, and coupled with that is, why are you here? What happened? And the patient will respond and tell you, okay? And so anything that's written down there came from her. How does that make it any more reliable? I'm suggesting it doesn't. It's simply what she told them. Is it surprising that medical people and law enforcement people immediately believe children? No, that's not unusual. Is it astounding that law enforcement and medical people, as a rule, tend to immediately believe a woman in and man domestic situation? That's not hard to believe at all. Okay? I'm not suggesting it's appropriate or necessarily true, but I think just in this world of ours, it happens. It happens. And so the female gets to be the victim and the male goes to jail. There, that's how we're going to handle it. Because when she, cries or tells her story, oh my goodness, it was terrible. And, he did this and he did that, and he did something else. Subliminally, I think people say, well, why would she say such a thing unless it was true? Write that out on a piece of paper. Why would she say such a thing unless it was true? You can switch just a couple of those words around and you can make it say, well, she said it, so it must be true. Which of course is not true of anybody. It's not true of anybody. We are not, the defense, as Judge told you, we're not required to produce any witnesses or offer any evidence. On the other hand, we did because our goal was to give you a rationale as to why Alyssa Clark's testimony isn't necessarily reliable and how it could aid you in terms of trying to explain some of the evidence that people have put forward and have now had admitted at this trial. The long story short, as you I hope now know, is that Mr. Clark, my client indicated that Alyssa Clark found out that he was sleeping with another woman, and ever since that time, she has just not been happy, and that the relationship between the two of them deteriorated. It seems like over time, and that there was a time a few years ago when she apparently complained about Mr. Brooks, and it appeared as though law enforcement was going to take the case forward. He was, my memory of the evidence in this trial was that Mr. Brooks was arrested, charged, and subsequently the case was dismissed. I was not involved in that. I'll just tell you, so I don't have any personal information beyond that. That's just what I gathered from here. And no fury like a woman scored is the thing that keeps popping into my head, but it is at least plausible. It's at least plausible that if she felt he should have been convicted, or if she felt that Mr. Brooks should have been jailed or punished or something, and that didn't happen, well, by George, next time, I'm going to make darn sure it happens next time. He didn't just push. He didn't just shove. Oh, he choked me. He choked me. Banged my head against the wall. Put a gun in my mouth. That'll get the police attention, won't it? You bet it will. And so the investigation was launched. We heard from our detectives. They interviewed Alyssa Clark and also Mr. Brooks, and we heard what was said to each of them. I'm particularly mindful of, and is the one about criminal sexual conduct in the first degree. Okay? Ms. Clark claims that she was not awake or alert or conscious when she believes a certain act occurred, but that subsequent she discovered a video, and she told us that that video was of her apparently in this unconscious state, and that Mr. Brooks penetrated her genital opening with his penis, and some other things that she told us. And the scientific world of the Michigan Department of State Police Crime Lab and the knowledge experience of the detective staff of the Lansing Police Department, what was the result? We didn't see any video like that. We didn't see it. Couldn't find it. Not there. Right? Really? Does that cause you to at least pause as to whether her story is reliable? I should hope it would. And then the testimony of Mr. Brooks, my memory is that he said, oh yes, we did engage in sexual intercourse that same day. Later, you know, I got her awakened in the shower, and you heard all that shit on it and so forth. But later that same day, when she was awake and understanding what was going on, yeah, we did. I'm lastly, and I'm finishing up here, but I want to talk just briefly about this idea of reasonable doubt, with the caveat that the judge is going to read that to you tomorrow, and that's the law that you are to follow. But here's what I think about this idea of reasonable doubt. Okay, I want you to suppose for just a moment that your vote was guilty on a given count. Okay, just walk with me a minute. You voted guilty on a count, and then you're dismissed by the court. People gather their jackets or purses or belongings, and did I leave anything back in their room? And you make your way out to the parking lot, and you're going to drive yourself home. Okay, and the first red traffic light that you come to, you're waiting. You're the first one in line. The light's red, and you're waiting for it to change to green. And you're tapping your finger on the top of the steering wheel, wondering, gosh, I hope I did the right thing. You did not do the right thing, because you obviously have a doubt. And if that doubt is reasonable, then you mark the box that says not guilty. On the other hand, if the opposite is true, same car, same traffic light, your vote has voted not guilty, and you're wondering, gosh, I hope I did the right thing. Yes, you absolutely did. That's how this works. Okay? So, Mr. Brooks has demanded a trial and consented to putting his future in your hands. I have assured him that he is in good hands, and that at the conclusion of the judge's instructions tomorrow, you will deliberate in a manner that will be suggested to you in a business-like fashion and so forth. You'll hear all that tomorrow. And that you're not going to rush to any judgment. Talk about it. Talk with each other. Why do you feel that way? What did you see? What did you hear? What makes you think that? Okay? Because as far as the defense bar is concerned, it's just an ugly thing if the first thing folks talk about at the deliberation room is, well, I think he did. What do you think? Yeah, I think so too. What do you mean you think? Why do you think that? What evidence supports that? And just because you think it, does that mean that you have absolutely no doubt in your mind, no reasonable doubt remaining? It's a serious matter. I know you'll take it seriously. You'll take all the time that you need, and that you'll follow your oath and render a just verdict.